Maybe, Your Lordship.
Yes.
Your Lordship, I extend my most apology for this honorable court. Your Lordship, I had made mistake yesterday, Your Lordship. Your Lordship, yesterday I have mentioned one item, Your Lordship, the DB matters, Your Lordship. The parties in this case were agreed to fix this matter on 18th. However, I have not informed this court, and this court had fixed this matter after 3 weeks. So, Your Lordship, I humbly pray this court to fix this matter on.
Matter is listed.
Not today. It was listed yesterday, Your Lordship.
Will not fix it.
Your Lordship.
Yesterday, the order has been passed
Yes, Your Lordship.
to list it after 3 weeks.
Yes, Your Lordship. All the seniors were there in the morning session, but Your Lordship, due to non-sitting of the DB in the morning session, they had to leave this honorable court due to some personal difficulty. They have
What is the urgency?
urgency, Your Lordship, there is an interim order, and this matter was fixed for hearing, Your Lordship. And moreover, this is the third round of litigation, I guess. This matter is pending since last many years, Your Lordship. In connection with this case,
What is the urgency which you cannot wait for 3 weeks? Your
Your Lordship,
property is going to
Your
be
Lordship,
damaged.
actually-
Your property is going to be damaged.
Your Lordship, my senior had asked me to get a date on 18. However, I have not mentioned this thing before this honorable court.
All
Last,
right, you make a mention on 18, then we'll see.
Your Lordship, there is a very least chance that DB will sit in this week, Your Lordship. That's why I'm making this mention today, Your Lordship. Please, Your Lordship. All the parties are agreed, Your Lordship.
You are giving a mention memo
Yes, Your Lordship.
for listing it on 18.
Yes, Your
Okay.
highly agree.
My lord, I beg to mention item number 4. The conducting council is out of station, so matter
Yes.
may be listed after 2 weeks.
Okay, after 2 weeks.
Much obliged.
Be pleased, Your Lordship.
Yes.
So in the earlier occasion, the petitioner was directed to file one amendment application along with affidavit. So today, I could not submit this because the petitioner is out of session. He is not contacting us. He said that over phone. He is at Delhi, so he will come. So today, sometime may be given.
How much time?
It will be better, my lord, after vacation.
Okay. On the prayer of Mr. U. Deka. Private counsel for the petition of list it after
Vacation.
6 weeks.
Okay.
Your Lordship, since leading council is out of station, so kindly matter may be adjourned today. And listed after 2 weeks.
On the prayer of your name?
T. Gamlin.
T.
Gamlin.
Gamlin.
Yes. Yes,
Landed counsel for the petitioner listed after 3 weeks.
much obliged.
My pleasure, Lordship.
Yes.
Lordship, in this matter, I'm informed that the pending SLP has been disposed of matter. So therefore, my lord, may I pray that my lord some more time may be granted, my lord, and in the meantime, my lord, I'll take instruction from the my department.
For what?
For furnishing of the copy or and the order judgment and order copy passed by the Honorable Supreme Court, my lord. That subject, my lord, SLP has been disposed of, my lord, as I am informed.
What is that SLP about?
SLP is, my lord, it is in connections to same, my lord, issue. And same issue was raised before the Gujarat High Court, my lord. And against that matter, my lord, the matter went to the Honorable Supreme Court.
Ah.
Now, the Honorable Supreme Court has already decided, my lord, in favor of the department, my lord, as I am informed.
Oh, in favor of the department?
My lord,
Okay. How much time?
my lord, 3 weeks time may be granted. In the meantime, my lord, I'll obtain the copy of the.
Are you
order
aware
passed
of
by
it?
the-
Yes, you know, there are two other similar matters, WPC 470, 470, and 472. They may be listed together.
Supreme Court has decided against you.
We had challenged the legality and validity of section 16 clause.
Are you,
4
are you,
CGST Act.
are you aware of the decision of the Supreme Court
I am
which
aware,
he is mentioned?
I am aware,
Okay. That has gone against you.
apparently.
Okay, then we'll dismiss it.
No, Your Honor, because I would require the conducting counsel from Guwahati to come in order to be able to respond properly.
Okay. And which are those other cases?
WPC
471, 472, my lord.
470, 471, and 472. There were
472 and 473.
My lord.
470.
70 is listed today, my lord. 71, 72, my lord.
No,
Altogether
71,
3 read petitions.
71 is listed today.
71 is listed today.
470,
I'm sorry, my lord.
72 and 73 are not listed.
470 and 472 are not listed.
Okay, 47. Third, Ms. T.Y. Bhutia, learned counsel for the petitioner, and Mr. M. Kato, learned DSGY, who submits that the similar issue contested before the honorable, the similar issue raised in the instant writ petition contested before the Honorable Supreme Court has been decided by the Honorable Supreme Court in favor of the state and against the petitioner.
Union of India.
In favor of the Union of India.
Madam.
Okay. And against the petitioner, for which he pressed for some time to produce the order of the Honorable Supreme Court.
Madam.
Also. In view of the above, and as prayed for by Ms. T.Y. Bhutia, and the counsel for the petition, list the writ petition along with WPC 470 of 2022 and 472 of 2022 after 2 weeks.
Madam. Deeply blessed.
Please, Your Lordship. Lordship, the impugned judgment is at page 26. Starts from page 26. The issue in the writ petition was the cancellation of recruitment, Lordship. The reasons for the cancellation of the recruitment was not told to us, and we had made various inquiries, and the only reason that they have told us was that it was an administrative decision. Now, when the writ petition was filed, they had filed an affidavit in opposition in which certain facts had come to light. And this honorable court had, after hearing both the parties, decided that the cancellation was valid in view of the fact that the administrative decisions which they have explained in the affidavit in opposition was for valid, on valid grounds, my lord. But Lordship, there is in the communications which were in the affidavit in opposition, some other letter was mentioned which was not placed before the honorable court, which was not filed. So in the affidavit in opposition, after the hearing was concluded, that communication was placed before this honorable court, a copy of which was not given to me. So I have no idea about that, but there is a mention about the same in paragraph 9 of the judgment, Lordship. Lordship may see paragraph 9, Lordship. That is at page 34.
Who will admit?
Lordship, in the meantime, after this writ petition, before this writ petition was filed, after cancellation of the recruitment, another advertisement was floated, which I had challenged in the writ petition, but till now, as per my instructions, no call letter has been issued yet, even though it was way back in December 2022, Lordship. So my prayer is that till this matter may be admitted till such time, Lordship, that may not be proceeded.
You are representing all the respondents.
My So, my lord, in this case, my lord, in fact, in the read proceeding also, my lord, there was no such interim, my lord.
No, there was
And my lord,
There was no stay order.
no, there was no stay order, of course. But Lordship, may I suggest, my lord, sorry, may I suggest, Lordship, since everything is there on record, let them place that communication which was let them give me a copy of that communication, Lordship, and matter may be listed after 2 weeks till such time only, Lordship. Lordship, the new recruitment process only to the post of UDC may be stayed, Lordship. Since there are no other parties, it won't take much time, Lordship. We can dispose of.
my lord, at this stage, my lord, the notice may be issued, my lord, the matter may be admitted, my lord, but no interim. My lord,
Mr. M. Dangan and the counsel for the appellant. Mr. M. Kato and the DSG
all respondents.
for all the respondents. Admit, call for the record. Yes. All the respondents are represented by Mr. M. Kato and the DSGY. No formal notice need be issued. Extra copy of the memo of appeal be served upon him during the course of the day. Since the parties are duly represented by respect and the council, posted to hearing after 4 weeks.
Lordship, in that case, Lordship, the interim may be considered, Lordship. Because if the interim is not given, then matter will become infractious, Lordship. Only till such time, a short date may be given, Lordship.
Just a moment, yes. What you are seeking is stay of?
Stay of recruitment to UDC, Lordship, only UDC. There are
What is the advertisement?
advertisement, Lordship, is at page 55, Lordship. Page 55.
My lord, for interim, my lord, we have objection, my lord.
Just a moment. Page 55.
Yes, Lordship.
Seven 12/2022.
Yes, Lordship. Even though it was issued then, till now, no call letter has been issued.
What is this 3rd August 2022?
This is the cancellation of recruitment, Lordship.
Okay.
Lordship, it may be taken up within a short time, Lordship, since there are no other parties, Lordship.
You want the matter to be taken up in a short time or you want,
If Lordship,
you want consideration of the interim order today?
consideration of the interim order, if it is a long, I mean, if
Okay.
a long date is given.
Okay. The Miss N. Dangalang, counsel appearing for the appellant, has prayed for an interim order for suspension of the advertisement number 07/2022 dated 7/12/2022. Issued by the Director NEIAFMR Pasigar. Notice Institute of Ayurveda and Folk Medicine Research and NEI at page 55. Insofar as the post of UDC is
UDC
concerned.
is concerned.
Post of. The aforesaid advertisement dated 7/2022. Sorry, advertisement number 7/2022 dated 7/12/2022 issued by so and so, Director so and so, was the subject matter of challenge in the writ petition number 7 AP of 2023, which was disposed of by the learned single judge, which was dismissed by the learned single judge by the impugn order dated, impugn judgment and order dated 25/8/2023. Also, it has been submitted by Mr. Kato Learned DSBY that there was no interim order staying the advertisement number so and so dated so and so during the proceeding of the writ petition. First, in view of the above, we are not inclined to stay the advertisement number 7 so and so dated so and so issued by so and so. List it after 4 weeks for hearing.
Lordship, can it be after 2 weeks, Lordship, since there is no interim?
4 weeks, nothing will happen in 4 weeks since call letter have also not been issued.
Lordship, in fact, I remember when this matter was taken up for the first time, your Lordship had said that since they are not, they have just only issued the advertisement, they're not going to do anything anytime soon. That is the reason why the interim was not given.
We don't know. I don't know. We don't know.
I recollect, Lordship, your Lordship was,
You may recollect. We don't recollect.
Lordship.
Yes.
So that is why, Lordship, can it be 2 weeks, Lordship?
For 4 weeks, 4 weeks.
All right.
My lord, this matter is being represented by AG. So today he is not here, so may I pray that this matter?
Item number 6.
Yes, yes.
You, okay, you are for the
State laws,
state.
yes,
As you will appear.
yes.
What do you want?
Lordship, after 2 weeks. also.
After 2 weeks?
Yes, yes.
Okay. Mr. D. Kamduk, Learned Standing Counsel for the Land Development submits that Learned Advocate General will appear in the instant case for which he pressed for adjournment of this case by 2 weeks. There is allowed listed after 2 weeks. I pray.
Much obliged. My lord, I am appearing for contempt number 5,
Contempt case.
contempt case. And today I have filed my counter on it, today only,
All right.
Occult number,
You are appearing for respondent. number?
respondent number 5.
Order has been complied with.
Lordship, I have not received the instruction yet, but Lordship, the little instruction I have,
No, you have filed the Wakalat number or the counter?
no,
order,
Occult number.
affidavit.
Only Okalatnama.
Then you, who is to comply with the order?
My lord, last time we were directed to serve the copies, we have done it. To respondent number 3 and 4, 3 and
No,
5.
no, see, there are so many respondents.
Yes, my lord.
Which respondent is to comply with the order passed by the court?
No, no.
Lordship, I am for one,
Ah,
one for, one and one, two and four, Lordship.
no idea,
Lordship.
no idea.
No.
Okay. On the prayer roll and the council for the parties listed after 4 weeks. There's no idea about the order passed.
My lord, by this appeal, I have challenged the legality and validity of conviction, judgment and order passed by the learned special court, Poxo, War Second District 0, my lord. My lord, in this case, I was convicted under section 17 of the Poxo Act.
London APP for the state. Since the LCR has been missing, as indicated in office note dated 19/8/2023, registries have prepared the paper book. The registries have prepared a paper book. Also. You said that the IA may be heard along with the appeal.
My lord,
Okay. Then you know. Okay. List it after the paper book is prepared.
yes. Must.
May I please mention, my lord, item number 6. Here I have received affidavit in opposition, so I'd like to file a reply. Therefore, matter may can be listed after 3 weeks.
Item number
6.
Item number 6.
Yes, ma'am.
Mike okay. Okay, on the prayer of Mr. D. Lazi, on the counsel for the petitioner, listed after 3 weeks, renewable filing of a reply.
Interim order may can continue.
Reply to the counter affidavit filed by the
State respondent.
interim order passed earlier shall continue till the next date of listing.
Also, please.
नहीं ये नया है ना कहीं कुछ उन लोग का भी तो काम नहीं कर रहा है क्या हो गया
This repetition, we have filed basically praying for a direction to the respondent to release our admitted pending HTS bills. Bills are admitted, claims are admitted. Page 189, Lordship, may kindly see.
Of which year?
This certificate is of 2023, my lord, 2nd of May 2023. Page 189, Lordship, may kindly see.
189.
189.
189.
This is to certify that as per office records of Director of Food and Civil Supplies, Government of Arunachal Pradesh, white number so and so, dated so and so, and order number so and so. The admitted pending HTS bills payable to the so and so proprietor of power attorney of following firms are as follows.
Oh, hold on. You appear for all. 1 and 2.
All year.
Huh?
There are
All.
only two respondents.
Okay. November. And Basar, notice 4 weeks. Extra copies.
My lordship,
Yes.
lordship, leading council, Mr. Titi Tara is out of station, lordship. Matter may be passed over for tomorrow, lordship.
What is the urgency?
Lordship, there is no urgency, lordship.
Okay, 4 weeks,
Lordship, maybe 3 weeks, lordship.
3 weeks.
No.
Okay. 3 weeks
Obliged, lordship.
on the prayer of Mr.
Okay, lordship.
K. Lolen, Senate Council for the petitioner listed after 3 weeks.
Obliged.
Otherwise, it was fixed at the instance of both the parties today.
That is why we are not inclined to fix a date. You fix a date and you run away.
Well, last time I told my learned friend that next time you, both of us should do, I will come and you will have to. He said, okay, now, today there is some event, of course.
Okay, fine. All right, after 3 weeks.
And
None appears. Listed after 4 weeks.
May I please also?
Yes,
Here, madam, our affidavit is ready, madam. I will be filing within a week, madam.
affidavit is ready
Yes, madam. Only swearing portion is left, madam.
for all the respondents,
For respondent number 6 to 9, yes, madam.
6 to 9.
Yes, madam.
Miss T. Wang, London Government Advocate representing respondent 6 to
6 to 9, madam.
6 to 9. Promise that the counter affidavit by the accused respondents is ready and the same would be filed within how much time?
Within this 1 week, madam.
Within a week. Then we are listed after 3 weeks. Yes,
My lord, I pray for some time in this matter, my lord, this is regarding to one reversal. I don't know what has happened now, but there was an interim order that has been vacated by your lordship.
It is regarding what?
Regarding reversion, ma'am.
Reversion, the functional one.
Yes. There was an interim order, my lord, that has been vacated by your lordship. So I'll take instruction.
Any idea?
Okay, it's just.
Okay, on the prayer of Mr. D. Pangala, counsel for the petitioner, released it after 4 weeks.
May I please, ma'am.
Yes,
My lord, I am appearing for 1, 2, 3, respondent number 1, 2, 3, my lord,
Hmm.
on behalf of standing council power. My lord. My lord, we need some more time to file counter affidavit.
how much time?
My lord, maybe a week or two, my lord.
Let it be a week, but your lordship will recall on the last occasion also, I made a submission that without any instruction from the respondent authority, the submissions are being made.
What
There's
is the
no-
matter about?
My lord, in terms of the rules, they are mandated to, my lord, have the seniority list. They don't have it,
They are mandated to,
yes.
What?
Have a seniority list,
or seniority list?
yes. They don't have a seniority list, when we are now.
Have you received
No,
Paravage comments?
No, ma'am, not yet.
But my lord,
But it is expected to be received by next week, ma'am.
Expected.
let it be fixed after, when the my lord will thereafter give them time to file. My lord. Notice was issued way back on 19 July or 29 July last year, man.
Okay, on the prayer of Mr. Dubey. On the council. On behalf of El Parliament, understand, further 2 weeks time is granted
My
for filing of a counter affidavit.
my lord.
Listed after 2 weeks.
Okay.
My lord, I'm on behalf of petitioner. We already served a coffee. Now we're waiting for the reply.
Who appears for the government?
What's the notice was issued on 31/5, lordship. We have
Hard miss.
communicated already.
Your good name?
Why it has come admission, I don't know.
Yes.
Your name?
Kyoda Yayo.
Kyoda?
Yayo.
Yalyo. On the counsel for the petitioner. And Ms. G. Ethel, on the additional senior government advocate representing both the respondents. Who press for and is granted for the 4 weeks time
Lordship,
to file counter affidavit listed after 4 weeks.
much obliged.
May I have your lordship? No, after service, my lord is written today, there is no affidavit filed by the respondent. The matter is relates to non-payment of compensation. Public rent.
Yes,
Affidavit from the deputy commissioner.
Well, some more time may be granted, my lord. In the meantime, we'll file affidavit.
okay, question is how much?
4 weeks time. my lord.
Okay. Mr. H. K. Deori, then the counsel for the petitioner.
And for respond,
Cutoff for DSJ
Respond.
for
1, 2, 5, my lord.
1 to 5,
1, 2, 3, 4, and 5, my lord.
5, and D. Kamdu for 6. And P. Sangita for 7 and 8. No, what about 9?
My lord, I'm sorry, man. Also
Okay.
9, my lord.
9, Mato for also 9. On the prayer of learned counsel for the respondents. 4 weeks further time is granted for filing of the counter affidavit. Listed after 4 weeks.
Deeply obliged.
Material. This is the transfer material.
For disposal or for adjournment? For fixing a next date.
And the matter may be heard and disposed as because all the pleadings are ready, my lord. And
Okay.
my lord, the issue is also very simple, my lord. Whether the partial modifications, my lord,
All right,
the transfer order,
then let him begin.
my lord.
Everyone is ready.
Yes, my lord.
Okay.
Your lordship may kindly have page 22, ma'am.
Yes.
This is the first order by which I am allowed to take charge of Pangani Circle. In view of the retirement of Sri Sasensas, Superintending Engineer PhD Circle Pangin on attending superannuation on 30 April 2023, until the posting of reliever Sri Tuba Angu is directed to take over the charges of SC PhD Pangin in addition to his normal charge. So, while I am functioning as PhD Circle, Superintending PhD Circle Alo Bena, I am allowed this additional charge also of Pangin. Then, my lord, you kindly see, this is dated as 27th of April. He goes on superannuation 30. At 23, my lord, the 1st of May, I take over charge, additional charge. 24, my lord, will see, this is the circular I issue that I have taken over charge. I mark it to all the concerned authorities. This first one. I forward the same to the chief engineer at page 25. Then the lordship will kindly have page 26, the first order.
26.
26.
This is the April order.
No, my lord.
Okay.
This is the first order. This is 30th of May. By this, my lord, I am a serial number 3. I am transferred from Alo to Pangin. Posted. The respondent number 4.
You are Tuba.
Tuba.
Alo to Pangi. Yes.
Yes. And respondent number 4 is posted in my place.
Respondent number 4 means
Oyukpad. Serial number 2.
Oyuk. Yes.
He is posted in my place.
Yes.
Then, my lord, at page 27 is a transfer of certificate of charge.
Council for respondent number 4 is also there. Okay. All right.
I transferred charge to respondent number 4 at page 27. This is dated 12th.
12/6.
Yes.
At Panging, you take charge.
I was not required to because I was already in charge there on account of the superannuation of Tamil.
Okay.
I was already there.
But what is this 27?
I hand over charge of Alo.
Oh. Yes.
I had already taken charge there.
All right.
28 is the document by which the respondent number 4 hands over charge to the other person who was posted in this place.
28 is the
Transfer of charge to the another person, Tony Ether, was a serial number 1 the transfer order. He was posted in place of respondent number 4. 4 is in place of me.
yes. 28 is
The handing and taking over of charge of the between the respondent number 4 and the person who replaced him,
okay. 28.
Tony Ether.
He is not a party here. Huh?
No, my lord, he is going
All
to
right.
tell you, my.
All right.
Then, my lord, the impugn order is at page 29. This is dated 12, but it is on 13th. At the bottom, your lordship will see.
Yes.
Now, my lord, the respondent number 4 is posted in my place as serial number 2.
Yes.
I am posted serial number 3 as SC sanitation. And the respondent number 5, all of a sudden he comes up and he's posted at Bene, Alo, in place of respondent number 4. This is within 13 days.
You have been posted at
AC Sanitation,
sanitation,
State Coordinator, SB.
respondent number 4 in your place,
Yes,
and
respondent number 5 at Ala, in place of respondent number 4.
5 is, who is 5?
Is Regam Bogo.
Ram Bogo. Alo, in place of respondent number 4. Okay.
Well, this is within 13 days, but once the transfer order has been issued, my lord, knows I have been making submission earlier also.
Hmm.
There's no reasons is assigned and nothing is discernible from the file also. They filed the file notice. Nothing is discernible. They just did it.
What do they say in the affidavit?
Affidavit, they say, my lord, Mr. Ratan was earlier appearing on they say that well, this is in the government's prerogative. That is the only thing they say. And they said it was not affected. Transfer was affected, my lord. On 12, I had already taken charge. I was already in additional charge. On 12, I had taken charge. The order came in 13. On the same day, my lord, respondent 4 also took charge at Alok. The transfer order, my lord, was complied with. My lord, no, our High Court has held.
First order is 30 May, is not it?
Yes, my.
Then 27 is, page 27 is the handing over of charge
Yes.
by you
Yes, by me.
to respondent number
4.
4. 20. Date, which date?
12, my lord.
12 June.
Yes. 12 day.
12 June is the impugn order. No,
No,
13
13.
June.
This is
Okay.
dated 12, but signed on 13. Memo number is 13. Memo
Then
dated.
28 is the.
Between respondent number 4
Okay.
and 128, who was posted in his place.
Yes.
My humble submission is, when once the transfer is issued in public interest, and if it has to be modified, that has to be done in overwhelming public interest. That has been consistently held by this honorable court.
Is it the requirement that once the formal transfer order is out,
Yes,
you have to again take charge? Earlier you were there as a.
but no, but because
additional-
that man was not there. He already retired on 30. Nobody was posted in this place. I was the person that was there.
All right.
So there was no question of I taking charge from anybody, because nobody is there to give me charge. The earlier incumbent already retired on 30 June.
Which is the judgment you rely on?
My lord, first judgment is, my lord, 1997, 1 GLP, page 140. Paragraph 8, man.
Yes.
Paragraph 8. This court in a catena of decision has held that for cancellation, modification, or keeping in abeyance of the transfer of public interest must be supported with sufficient reasons necessitating for passing such order. The view taken by this court is rational behind it. Once the transfer order is made in public interest, court normally do not interfere unless the order is passed with mala fide or other or against the statutory rules. The only way open to the aggrieved government servant is to file a representation before the competent authority to redress his grievance. But this court insists that for cancellation, modification, or keeping in abeyance of such order must be supported with sufficient reasons, because transfer of officers are always made in public interest, and after elaborate exercise as to who should be transferred where in the exigency of administration. While proceeding a transfer order, various factors are taken into consideration. One such factors being the duration of the stationing of one officer in a particular station for a long time. If an officer is posted in a particular station for a long time, no doubt that he also acquires considerable knowledge about administration of the area, but at the same time, he also establishes a vested interest in the area because of his long association and with such eventualities, timely posting is always called for. Therefore, if the transfer order made in public interest is allowed to be taken away by another cryptic order, modifying, cancelling, or keeping an abeyance of the transfer order without assigning any reasons, it ceases to be in public interest. Therefore, it must be held that the order has been passed at the whims and caprice of the authorities exercising the power. public interest would not be allowed to be sacrificed at the altar of whims and caprice of the authority exercising the power. It must be grasped that public authority possesses power to use for public interest.
Yes.
This has been followed in manner 2001, volume 3, GLG 67.
Hmm.
This is-
Okay, all right.
Same thing.
Anything else?
That's all. Because they have filed the file notice, nothing is discernible from there.
Yes,
No reasons, nothing, absolutely nothing.
I think government first, no?
We have a limited case.
Ah.
So far this case is concerned, the modifications is not supported by the region also. That is, from file noting, I am not able to find out also, the region also. But it was, it has been done also as an instance of the honorable minister also. And what he did is, it can be understood, he has done in the interest of public. And noting Malapai also he has been raised in the present petition. That part also has to be considered because Malapai is not there. And from file noting lawsuit, also it is very clear lawsuit, as I've submitted lawsuit. The honorable minister concerned was. He is initiated.
At page.
Page 16.
Kindly come to my affidavit lawsuit, page lawsuit,
16.
16 in the file note.
page 16 of my affidavit lawsuit.
Yes.
I'm taking lawsuit to the middle paragraph lawsuit. The typed one lawsuit. The file has been recalled for modification regarding transfer of posting of SC so and so, proposed at page so and so. Is submitted with a slight modification. Honorable CM may like to see for approval please. And this was the lawsuit, proposal lawsuit.
Okay.
And here lawsuit, if lawsuit see that
This proposal has been approved. is it?
this proposal, except for the respondent
no.
number 3, sorry, serial number 3, Tuba Angu lawsuit.
Ah,
He was proposed to be lawsuit SC Banner lawsuit.
okay,
It was not accepted lawsuit.
all right.
He was proposed to be written at Banner lawsuit. He was already at Banner. So since he has already completed 7 years in this particular posting place lawsuit, so therefore this proposal was not accepted. But for 1 and 2 lawsuit, it was accepted. So here also what I'm trying to point out this lawsuit. It has been initiated by the honorable minister concerned lawsuit. And he being a lawsuit, the representative of the state and public laws. It can be understood also he has initiated in the interest of public laws. And I'm repeating lawsuit since the Malapai is not the issue here. It's not that in a for some Malapai region or some alternative motive lawsuit it has been done. Because even the minister is not party in the writ petition. Apart from that lawsuit, in compliance of the subsequent order lawsuit, this is the transfer order. The petitioner has not joined in the place lawsuit. If this connection, kindly come to page 9 of my affidavit lawsuit. Page 9.
Now, at page 16,
Page 16 lawsuit.
if this chart, if this table was the proposal, what is the approval?
Approval
With modification?
lawsuit on next, kindly come to page 18 lawsuit.
Because
At the bottom,
one and place suggested for person at serial number 1 and 2 have been accepted.
Lawsuit. And down below lawsuit for fine. The serial number 1 and 2.
C
is
may be
approved.
posted as SC sanitation and such and such.
Okay.
Yes.
All right.
It does not even suggest because of my length of practice.
All right. Yes,
Then kindly come to page 9 lawsuit.
page 9.
9 lawsuit.
The petitioner was already in Bene at that point of time, Lordship, Alo Bene, as a SC Lordship. On retirement of Tamuli Tako, then SC, who was in charge of Pangin Lordship. On his superannuation Lordship, for administrative region Lordship, the petitioner was only directed to take over the charge as an addition to his charge as a SC Bene Lordship. He was till some new incumbent comes to that post. That was the only arrangement. And this arrangement has been made by the chief engineer, who is not the transferring authority, but he is the controlling authority who can make arrangement in the interest of public laws among the officials. Now, in compliance of this very order issued by the chief engineer, the petition took the charge, additional charges.
Yes.
Now, the transfer order was issued on 30 May. And in terms of that order, he has not joined us. In our affidavit also, we have issued lawsuit. He has not joined. The extent of the petition is that since he has already joined there, he was in additional charge. So therefore, no further charge is required to be taken. This is his extent in the matter. Now, Lordship, my only attempt to make a distinction, Lordship, the cases which my friend has cited. On those cases, Lordship, the petitioner has already joined those. Here, because one is the public interest, other one is Lordship prejudice to the petitioner himself, because some hardship is caused to the employee when he is Lordship only joined in terms of the order, and when modification comes, it causes Lordship some sort of hardship to the employee, and also it's against the public interest. One part, Lordship, the public interest must be transfer order must be modification must be supported by the region Lordship. That part, Lordship, we are admitting Lordship region is not on the request. Second part, Lordship, the petitioner has not joined in terms of the earlier transfer order laws. Accordingly, the transfer order has been modified. So therefore, Lordship, this distinction I would like to make also. The present case, the facts of the present case, and the cases where Lordship, the issue has been laid down. Once transfer order has been issued in public interest, for modifications, it must be supported by the regions. And that's all. That's my limited submission.
Yes.
May I please, Your Lordship? Lordship, at the very outset, my lord, may make submissions in continuations to the submission made by the Council for the State, my lord. No, my lord, reason has been assigned. The reason has been, my lord, specifically given in the file noting also, my lord. Admittedly, my lord, in the impugn, my lord, the transfer, partial modification order, my lord, everything is not reflected, my lord. However, my lord, in the file, therefore, the file noting has been enclosed in the annexure of the affidavit filed by the state respondent, my lord. Specifically, may I take your lordships to the file notings, my lord? It is specifically mentioned. Once again, my lord, just for clarity, my lord, may I take your lordships to do my lord, the file and the file notings, my lord? My lord, it says it has been specifically mentioned, my lord. The reason is only after the transfer order issued by the respondent authorities, whereby the transfer and order has been issued, by which the petitioner has been transferred to Pangin circle, my lord. He was serving at the Bene circle. Thereafter, by 30th May 2023 order, he has been transferred to the Pangin, my lord. Thereafter, my lord, what happened? Another file has been initiated at the behest of the petitioner with the minister. The concerned minister has recalled the file of the petitioner, and the modification has been done for his retention, my lord, specifically, my lord. So therefore, my lord, the retention order, my lord, it is, may I take your lordship to the page number, my lord. First, I'll go by the affidavit of the my lord, the state respondent, my lord, respondent number 1, 2, and 3, my lord. My lord, initially, the file noting was for the transfer and posting of the one officer, namely, my lord, Tony at the my lord. This is annexure 5, page number 13, my lord.
Page number?
13, my lord.
13.
Yes, ma'am. The self-explanatory representation of Mr. So and so, along with two officers, two nodes of UO, so and so, of so and so, assembly, so and so, my lord, I'll skip them. The Arunachal Pradesh, so and so. Data regarding the request for promotions and transfer and postings of the ER Tony at the executive engineer, so and so divisions to superintending engineer, so and so, wherein the deputy chief minister, government of Arunachal Pradesh has recommended for consideration on the body of the UO node, which may be seen at phase number so and so. As per the records, the sanctions strain of the the superintending engineer, there has 8 the first only, and so and so. Why I'm reading this? This is particularly in respect of the one officer, namely Sri Tony at the I'll skip rest part, madam. The next phase, madam. Next phase, page number 14, sorry. The supervision of AC PHE Pangin Circle and MS Tamuli Tako, the has created a vacancy. Therefore, the following transfer and posting is proposed, madam. By this, madam, the proposal, the ER Tony at the Alo, the proposed transfer is in charge AC Teju Circle, madam. In this case, in any case, his case is not affected, madam. And serial number 2, O Padung, madam, who is responding in present repetition, O Padung, AC Teju, the proposed transfer is AC Alo Bene PH Circle. And third serial number 3 is Sri Tubango, the present petitioner, to propose to the AC Pangin, madam. And the Honorable the Chief Ministers may likely to approve is approved. Accordingly, this has been approved. And the transfer and posting order was issued by the order dated 30th May 2023, madam. 30th, madam. And that has not been given effect, even to that effect, that they have not the join, as rightly pointed out by the Council for the State, the senior government advocate, that has not been effected.
If the incumbent does not join, is it the law that you can modify it without a reason?
Exactly, madam.
Let us see that law.
There is a always the open to the state respondent to modify the order.
See, the decision relied on for the proposition that in so far as the modification of a transfer order is concerned, it has to be for a sufficient reason. There it does not say joining, non-joining.
Yes, ma'am.
Right.
Correct.
If you can show us anything that if the transfer order issued, pursuant to transfer order issued, if the incumbent does not join to that place of posting, then it can be modified even without a reason. Then you will get out of this judgment.
Admittedly, so far I haven't find the specific way, the queries fallen from your lordship. But there is a one order. The once transfer order is passed, the competent authority has a right to cancel it or modify it. There is a I'm repeating, the once a transfer order is passed, the competent authority has a right to cancel it or modified even after it issued executed, my lord.
Even after it is
Executed, my lord.
executed. Yes.
I'm sorry, my lord, I have marked the
Which-
highlighted one.
Which
The
court?
highlighted one, my lord.
Which court?
It is, I'm sorry, my lord. I'm having the only one single copy, man. I'm sorry, my lord. So otherwise, my lord, law is very clear and it is
This
set up,
is of Allahabad High Court.
my lord. Otherwise also, my lord, the power to transfer, power to modify, my lord, power to, my lord, the issue transfer order is always vested with the competent authority, man. It is settled position, my lord, in the
But
2004-11, my lord, SEC.
even if it is correct, we will have to follow the Guwahati High Court law.
My lord. Now, my lord,
We are even assuming that this is correct
Yes.
position of law.
my lord.
Nothing
Otherwise
is-
also, my lord, 2004 is the settled position, my lord, settled law, my lord. Once that, my lord, the
See, if you want to rely on this,
Fine.
you have to give a specific citation,
my lord.
not like this.
I'm sorry, my lord, I'm giving, my lord, I'm permitting. So therefore, my lord,
Yes.
no, my lord, that is, that one is different, my lord.
Hmm.
Now, my lord, again, may I take your lordships to the page number, my lord? That order has been issued, my lord, the order dated, my lord, 30th May 2023. That has been never complied with, my lord. None of the parties, my lord. Again, my lord, after, my lord, issuance of that, my lord, the first transfer order, this partial modification, my lord, specifically, may I take your lordships to the page number 16?
Hmm.
This is the, my lord, only reason, my lord, how the partial modification order was issued by the competent authority. The file has been recalled. My lord, who has done this? Concerned minister. The file has been recalled for modification regarding the transfer oblique postings of the ACs and PHE water supply and proposed at page number 72 is resubmitted, my lord, with a slight modification. Slight modification, the Honorable Chief Ministers may like to see for approval, please. And that is, my lord, serial number 1 remain as it is, my lord. Serial number 2 is also remain as it is. Now, my lord, serial number 3, who is the petitioner?
No, this we have seen. Here you will not find reason.
My lord, now reason is, my lord.
Mr. Kato,
Yes, my lord.
with this nothing, you can't defend your case in the light of this 1997 GLT.
My lord.
If you want to do a research on what to distinguish it, that if the incumbent does not join, then it can be modified even without a reason. Today, I think you are not equipped with that.
My lord, the reason is,
Otherwise we will understand this judgment has to be understood irrespective of joining.
my lord.
Because it does not say about joining. It says modification of a transfer order. Issue.
My lord, true, my lord. It is also, my lord, I am aware, my lord, that it the settled positions of our own High Court, my lord, the once the partial transfer and the partial modification order is issued, my lord, that should be, my lord, with reason order, my lord. The reason, my lord, what try to point it out is at annexure, same annexure, page number 16, my lord.
16, yes.
My lord.
This
is the only reason, my lord.
We have seen that, but
Everything has not been reflected in the order sheet, my lord. But this is the file notings by which, my lord, the impugn transfer, my lord, is impugned in the, my lord, writ petition. This is the reason, my lord. My lord, may I read again, my lord?
Yes.
Serial number 3 is, my lord, the petitioner, AC Bene Circle, Bene Alo. 2, my lord, AC Alo proposed, my lord. He has been in the same place of posting for last more than, my lord, 7 years. The Honorable Chief Minister, without approving, my lord, just modified the order, my lord, serial number 1, 2 is approved, my lord. In respect of serial number 1 and 2 is approved, my lord. And in respect of my lord, serial number 3, who is the petitioner?
Yes.
Serial number 3, Sri Tuba Ango, AC Alo may be posted as AC Sanitation State Coordinator, the HMBMG.
That
And
is,
Sri,
that is the issue.
my lord.
Why he should not be there at Pangi? As approved by yourself. Yourself means Mr. Tapin.
My lord, the reason is, my lord, he has applied for the retention, my lord. Retention,
Petitioner.
petitioner, my lord, it is reflected in the, my lord, just we have seen. My lord, this is the retention, my lord.
Which
Just
one?
my lord,
Which one?
again, may I read, my lord?
Uh,
Slide modification, my lord. Noting with file noting slide modification. Present place of posting, serial number 3, my lord. Tuba Angu, here Tuba Angu, Eshi Vene Alo. My lord, he is proposed, again proposed, my lord, instead of going to, my lord, the Pangin circle, as per the earlier transfer order, my lord, 30th May 2023.
No, this is proposed by the
Exactly, my lord, this is the
department.
My lord, proposal.
He has not written for retention. Did he write for retention?
No, my
He did not write for retention at all.
my lord, it is, my lord, as per the government, my lord, the affidavit filed by the state respondent also, my lord, it is clearly reflected, my lord, may I take your lordships to again, the statement made by the state respondent in the their affidavit, my lord.
Yes.
Paragraph, my lord, 7, page number 4,
Paragraph 7.
my lord.
Just a minute.
My lord, rest but I'll scheme.
Paragraph 7.
7,
Yes.
my lord.
Page number 4. Yeah.
My lord. With regard to the state abatement made in paragraph 6 of the writ petitions, the answering respondent denied that the petitioners assumed the charges of the SC so and so fine as per the order dated 30th May 2023. The petitioner assumed the charges of the so and so Pangin in addition to his substantive post as AC so and so Alo on internal temporary office arrangement as per the order dated 27 April 2023 issued by the Office of the Chief Engineer, PHE so and so department. I'm saying due to retirement of earlier incumbent Sri so and so secretary PhD and has not received any joining report from joining report by the petitioner based on the transfer order dated 30th May 2023, my lord. This is important. Next paragraph, my lord. The office of the Chief Minister, PHE, my lord. This is the, my lord, only turning point. Had called back the, my lord, the concerned file for modifications of the transfer order dated 30th May 2023. From the noting, it is seen that the proposal for retentions of the petitioners at petitioner Sri E.R. Tuba Angu at Alo Banner and the postings of the E.R. or Fatums to the Pangin from Teju was proposed.
Proposed by whom? By the department. He did not write.
On the last occasion also, my lord, it was admittedly, my lord, pointed out by the learned AAZ. My lord, they are concerned for just posting and transfer of such officers and grade 1 officers, my lord, the approvals of them, my lord, the Honorable Chief Minister is required, my lord. But the proposal was done by the Chief Minister, concerned Minister, my lord, concerned Minister PHE. He has proposed for the retention, my lord. Then, my lord, it goes forth to the Honorable Chief Minister, and Honorable Chief Minister has modified, my lord.
All right.
My lord.
Department had proposed.
Not exactly, my lord, department. My lord,
Who?
Minister, my lord.
Okay, minister had proposed, but not the petitioner.
Not the, my lord, as per the file, not, my lord, from reading, my lord, how this has been initiated, maybe, my lord, it has been initiated on the basis of the, my lord, the proposals done by the petitioner, my lord.
Where is that? Where is this? That is what we are looking
my
for.
lord, this is the only difficulty, my lord, the way, my lord, everything is not reflected by the, my lord, behind the, my lord, the scene, my lord, it is the only petitioner who always prepare for the, my lord, retention at one particular place of posting.
We must not look at what is not visible.
My lord.
You must not
Otherwise,
throw that.
my lord,
You
how,
must not invite the attention of this court,
just it is,
which is not a matter of
my
record.
lord, it is also seen how the minister himself, concerned minister himself.
You may say anything against him, but he did not write. It's not for retention. Okay, all right.
Now, department affidavit is very clear, my lord. Concerned minister. However, they said approval was not considered owing to the, my lord, the fact that the petitioner has already served as, my lord, this is the important, my lord. However, they said proposal was not considered owing to the fact that The petitioner has already served as AC, PHE, and W-based circle ALO for more than 7 years, which exceeds the prescribed period of 2 years at one place of posting as per the state's policy on transfer and posting, resulting in modification of the transfer order dated 30th May 2023 and issue of the transfer order dated 12 June 2023. The said proposal was further modified and the petitioner whereby the Sri Tuba Anu was posted as the AC sanitation the Rekambogo was posted as AC Alo Bena Circle and the O Padung was posted as AC. But the reason assigned by the Malad state respondent and by way of affidavit is the only Malad is clear, very much clear, Malad. And the Malad again, I may take your lordship to the next paragraph, paragraph 8, Malad.
The minister had proposed, isn't it?
Malad, concerned minister.
Yes.
So, approval has to be done by the Honorable Chief Minister, who is there. Paragraph 8, Madam. Same page number 5. With regard to the abatement made in paragraph 7 of the writ petitions, the answering respondents begs to state that the concerned transfer oblique postings file was called back by the office of the minister PHED. From the file noting, it can be seen that the proposal for modification of the transfer order dated 30th May 2023 was proposed with the retentions of the petitioner, Sri E.R. Tuba Ango AC at Alo Bena and posting of E.R. O Fadung AC to Pangin from the Teju. However, the said proposal was not considered for the reason as stated in the paragraph 6 above, the same for more than 7 years. Above, the resulting in modifications of the earlier transfer order and the issue of the subsequent transfer order whereby the petitioner Sri Tuba Ango was posted as the AC sanitations, the SBMG in place of the ER to Regambogo, who was posted as the AC Alo Pene Circle and the OR Padung was posted as Pangai Circle. Moreover, the transfer and postings being a policy matter cannot be a ground to disregard the government order when the incumbent petitioners has overstayed at one place of postings as prescribed by the state, the government notifications, which limits to 2 years at one place of posting. Out of that, I'm also helpless to particularly pointed out how this has been initiated. The initiation as per this affidavit, initiation has been done from the concerned ministers for the proposal was given and it was sent to the competent authority for approval. The competent authority without affecting the other the officer concerned, just this transfer in the partial modification order was issued. Basing on the again, just may I take your lordships to my affidavit, This is in respect to the affidavit filed by the state respondent number 1, 2, 3. In my affidavit, I have clearly stated, pursuant to the partial modification order, I have joined, annexure, 1 is the transfer order, my affidavit, respondent number 5, affidavit filed by the respondent number 5. Annexure 1 is the order, and annexure 2. Page number 16,
Affidavit by respondent number 5.
5,
Yes. Page number?
Page number 15, annexure 1. This is the same transfer order, partial modification. And the annexure 2, page number 16, by which the respondent number 5 has been released, enabling him to join at his new place of posting. It was on 14 June 2023. Accordingly, I joined. Joining report has to be given to the chief engineer of the Eastern Zone at Namsai. Annexure 3, page number 17 is the joining report.
But there's a stay order.
My lord, stay order was subsequent, my lord.
Okay. So,
Stay order was granted by this honorable court on 20th, my lord, after my joining, my lord.
okay. Where are you now? You must be in the earlier place of posting? No, here.
No, my lord, in fact, my lord, by my lord, the operations of the, my lord, the stay order, my lord, after joining, my lord, I'm there, my lord. I have not gone back to the, my lord, of course, my lord, there is a stay order, my lord, but after joining, my lord, the stay order, whereby, my lord, we have also prepared, my lord, the caveat petition also, my lord. This is the, stay order is, my lord.
Anyway, that joining is hardly makes any difference. Joining, anyway, that joining hardly makes any difference here and there, isn't it?
Admittedly, my lord, after joining, my lord, my lord, there is a, my lord, difficulty on my part, my lord. After my joining, I am nowhere, my lord. I'm neither I am taken back, my lord, nor there is any order, subsequent order, my lord, allowing me to, my lord, remain in the join, my lord, new place of posting, my lord, where I've joined. My lord, joining order is at page number 17, and my lord, handing and taking over, my lord. After issuance of the transfer order, my lord, the partial modification order, my lord, the petitioner is not in the, my lord, the station for last so many, my lord, months. Accordingly, my lord, I have to cover the charges, my lord. It is page number 4. Sorry, page number 18 and extra
No,
4.
no, just a moment. You are representing respondent 4 or 5?
Respondent number 5, my lord.
5.
Yes, ma'am.
Regam Bogo.
Yes, ma'am. Yes, ma'am. Petitioner has been transferred
You are
twice
at,
the respondent.
you
number.
are at Alo.
Yes, madam. I've taken charges, madam. Expertise, of course, expertise charges was taken, madam, since the petitioner was not available in the station, madam, in the office, madam, as well. Annexure 4 is the handing and taking over, madam, of the charges, madam. It was done on, madam, the 15th June 2023, madam. And the, madam, circular was issued by the, madam, the petitioner, Annexure 5, page number 19, madam. By this has been by this, my lord, every, my lord, the concerned authority has been informed, my lord. Page number 19, my lord. And page number 20, my lord, annexure 6. My lord, this is the only, my lord, we time and again we have raised, my lord, this is the only, my lord, the manufactured document, my lord, this has been, my lord, the fabricated.
Now, my lord, if he starts arguing, then my lord, I will pray for it.
Just a moment.
On 14, my lord, I took over the charges. And on 20, my lord, this honorable court has passed the interim order by staying the operation of the, my lord, the partial modification order.
You are now at Alo.
Yes, madam.
Where is this respondent number 4 now?
Respondent number 4, my lord, as per their affidavit, they are only saying that no, they have, my lord, as per the version of the petitioner, my lord, he has joined at, my lord, my place where I am presently serving. But as per the affidavit of the state respondent, as well as my affidavit, my lord, he has never joined, my lord. None of them has executed, my lord, as per the order, complied the first transfer order, 30th
No,
May 2020.
You say that you are now at Alo.
Yes.
Where is this respondent number 4?
Respondent number 4, my lord, so far he has not joined. Even his affidavit also very much clear.
He is at Teju.
My lord, he, as per the affidavit, my lord, the affidavit filed by the respondent, he has not joined at Alo, my lord.
Where are you now?
Your lordship, I have already joined my posting place
At-
at Pangi.
Not Pangin, Alo.
It's Alo, yes, Your Honor.
There's a stay order.
My lord, so.
When did you join at Pangi?
Your Lordship, this specific date is not mentioned.
Huh?
Stated.
Date is not mentioned.
Your Lordship, in my case, I have just complied with the same order dated of posting. And I have already joined my posting place of Your Lordship. And
At-
I have already stated in my affidavit in opposition, that is in paragraph 5.
When did you join at Pangi? As per your affidavit?
Your Lordship, this
Date is
specific
not
date
given.
not mentioned.
Okay, date is not mentioned. Then where are you working?
Your Lordship, I was working, earlier I was working at.
No, now. If you have joined at Pangi, where are you working?
Lordship, as I have mentioned, it's SCPHE and Circle Pangin.
Huh?
Lordship, I have to correct it. Your Lordship, as per the order dated of
Order we are aware of.
Yeah.
According to you, according to your affidavit,
as per
where
this
have you
order,
joined and where?
My posting address, my posting place is from Teju PHE circle to posted to SCPHE Pangin. It's in Your Lordship, the.
That is under challenge. Where are you now? This question is put to you because respondent number 5 is saying he is in Alo. That's why only. Otherwise, for no.
Your Lordship at Teju PH.
You are at Teju now.
I have posted from.
You joined at Panging and now you are at Teju. Are you saying it from your affidavit?
They filed an affidavit,
Hmm.
paragraph 5.
Paragraph 5.
What do they
May
say?
kindly tell,
Alo.
Paragraph 5.
Alo.
Ah.
You are there at Alo.
Yes, sir.
Then how can you be at Alo?
No, that is the only case. Even after my joining, he was not there. Subsequently, my lord, this is the only manufactured document by which they wanted to demonstrate it before this honorable court.
From where are you drawing your salary?
My lord, I am supposed to draw, my lord, as per the order passed by your lordship, my lord, it is from the Alo, my lord.
Alo.
I don't know, last occasion and submission was made that I am nowhere, I am not getting salary also. So you
My
also
lord,
observed that-
practically, my lord, I have joined.
That's all.
My lord, by interim order, I am not in the, my lord, after my joining, my lord, if stay order is passed, my lord, where I will be? Neither I am going back, nor, my lord, I am allowed to, my lord, discharge my duty as AC at Alo, my lord. After my joining, my lord, interim order has been passed by this honorable court. Meaning there, my lord, I am there at Alo. I have not gone back. It's because I have been already released. And I have joined also, my lord. But my lord, practically, my lord, physically, my lord, practically, my lord, he has not joined at Benesar, my lord. Alo, respondent number
No,
4.
Your Lordship, I have already joined at Alo. As per my.
My lord, they're making only such statement is on the not my lord,
Anyway, that will not make any difference in the decision which the court is going to pass. Yes.
I'm sorry, my lord, I'm not following. My lord.
No, the joining will see whether whoever is wherever,
My lord.
that will not make
No,
any difference
exactly, my lord, exactly, my lord.
on the legal issues
True,
that
my
has
lord.
been raised.
True, my lord. My lord, the only thing is that whether the partial modification order passed by the, my lord, the respondent authority is, my lord, in consonance with the, my lord, the policy guideline, or whether the justice power is, my lord, vested with the state government or the competent authority is the only, my lord, the questions to, my lord, as per my understanding, my lord. The partial modification time and again, my lord, as pointed out by the counsel for the petitioner is, no reason has been assigned while issuing the impugn, my lord, the partial modification order. But my lord, my respectful submission is the impugn, my lord, partial modification order has been issued by the competent authority basing on the considerations that he was proposed, he initiated for the purpose, initiated for his retention at one place of posting at Pena Circle for more than 7 years. If petitioner is retained, if petitioner is retained again at Bene, he has been in the past one posting place for more than 15 years, more than 7 years. So therefore, this is the only.
There's one more writ petition by you.
Yes.
Are we hearing this also today?
In fact, on the, as per your lordship's order, copy has been already served, that part, will skip,
Okay.
Only thing is that,
I will not be in a position today.
copy has been served, to the.
Copy, we need to start.
Okay, but we are not hearing the other writ petition.
Now, the affidavit, therefore, time and again, I am pointing out, this documents has been manufactured by the respondent, the respondent number 4 in connivance with the petitioner. Nowhere, he has joined.
If the submission comes, then this has to be taken up with other writ petition.
Hmm?
If this submission is made, then the other writ petition will have to be taken up. I am not in a position to argue that. That copy has not been
It's not
supplied.
that we are not raising any of such the queries in our affidavit, It is also same at the same time, we have raised in our affidavit, It is nothing new,
In that case, this has to be hard together,
Where is the question of the hard together,
That was the understanding. That was the understanding on the last occasion.
Same things has been raised in our affidavit, may kindly peruse, how these documents has been manufactured,
In that case,
Malad,
I pray
specifically-
for adjournment,
The only raising for the such issues in our affidavit, where's the question of the adjournment, has already pointed out, has observed that
That was
the
the
matter can be
understanding
heard,
of our
matter can be disposed of. But since parties are ready, that was the queries at the very beginning by your lordship. And we have agreed to it. Where is the
Then
question of
don't argue on the fourth part.
First part, we have also raised in our affidavit, may kindly take your lords, may I take your lordships to, the affidavit, of my same affidavit. We have raised, it is not that new, we are raising the issues for the first time, This same issues has been raised in our affidavit also, That the criminal writ petition is something different, It is for the initiation of the appropriate action against the petitioner who has manufactured entire documents, Being a government, senior government officer has manufactured entire thing, So therefore, may I again take your lordships to the affidavit filed by the respondent number 5. Lordship has already seen my joining, my release, my joining, even assumed charges.
Yes.
Paragraph 7 of my affidavit, Page number, it starts from page number 4. Why am I relying upon this? This is the only as lordship has already seen how the petitioner, the respondent number 4 has joined at my place, even after my joining, This is not correct, Neither respondent number 4 has joined at my place posting, nor the petitioner has joined at new place of posting at Pangin, he has also admitted in that the factual position in affidavit also.
Does the joining makes any difference?
No, admittedly.
Huh? Don't make a difference.
However, therefore, this is a suppression of material facts, Why without joining, he is making such a statement on affidavit that yes, I have already joined. This is something misleading to this honorable court. Suppression of material
Then
facts.
if the joining does not make any difference, then there has to be a reason for modification.
Admittedly,
So if there is no reason, then we'll have to interfere with
So therefore,
the modification order. So I am repeating what I've said earlier. The legal issue which is coming up for decision here is that you can modify, but there has to be to use the language of the court, which he has relied upon. sufficient reason.
Correct.
Reasons, what we have seen, it is not there. According to you also, according to Mr. Tapin also, it was the PHE minister who called back the file and put a proposal.
My lord.
And then with slight modification,
Correct.
it was done.
That is the reason.
No, that is not the reason. That is how the modification was done. Now that will be hit by this judgment. See, once the transfer order is issued, it is deemed to be issued in public interest. So if you want to modify it, there has to be a sufficient reason. For sufficient reason only you can. Now, earlier you had tried to show one judgment from the Allahabad High Court that the transfer order issue can be modified, cancelled also by the competent authority.
My lord.
Now here in this judgment, it does not say about joining, not joining. It only says once the transfer order is issued, you can't modify it without a sufficient reason. If you want to get out of this judgment, then you may have to find out a supporting decision. If the incumbent pursuant to the transfer order has not joined in the place, then it will be open for the respondent authority, state authorities, to modify it without reason also.
My lord,
Now-
2004,
Huh.
11 SSC, my lord.
Govardhan,
My lord.
yes,
This is the settled law, my lord.
settle.
Yes, ma'am.
Here does it says about, yes, what does it say?
My lord, unless it is more than modified, my lord, with that, my lord, in violation of the statutory provisions, my lord, if such, my lord, is not complied with, my lord, the transfer and order is, my lord, even without, my lord, the partial assigning something,
No, this is of the transfer order.
my lord.
This is not of the modification.
My lord, modification, my lord, is supersede, my lord, is because, my lord, the entire, my lord, transfer and postings, my lord, order issued by the competent authority is, my lord, is within the domain of the, my lord, state respondent, my lord. Is authorities, my lord, competent authorities.
Which paragraph? Let us read.
Paragraph, my lord, 7.
Hmm.
It is too late in the day for any government chairman to contend that the ones they appointed or posted in a particular place or positions, he should continue in such place or posting as long as he desires. The transfer of an employee is only in incident inherent in the terms of the appointment, but also implicit as an essential conditions of service in the essence of in absence of any specific indications to the contract in the law governance or the condition of service, unless the order of the transfer is shown to be an outcome of malified matter, exercise of power or violation of any statutory the provisions, an act or rule or passed by an authority not competent to do so, an order of the transfers cannot lightly be interfered with as a matter of the course of the routines for any or every type of the grievances sought to be made. I'll skip this part. So even the administrative guidelines for the regulating the transfers of the transfer or continuing the transfer policies is at best may afford an opportunity to the opportunity or the servant confers to the approach their higher authorities for redresses, but cannot have the consequences of depriving or the denying the competent authorities to transfer a particular officer's of the servant to any place in public interest is the pound necessitated by exigencies of service as long as the official status is not affected adversely and there is no infractions of the any career prospects as such the seniority, scale of pay, the security emoluments. The court has often reiterated that the orders of the transfers made in transgressions of the administrative guidelines cannot also be interfered with is they do not confer any legally enforceable rights unless is notice supra shown to be vitiated by malefides or is made in violations of any statute provisions. And the next paragraph, a challenge to an order of the transfer should normally be issued and there should not be the continuance by the courts or the tribunals as though they are appellate authorities over such orders, which could assess the niceties of the administrative needs and the requirements of the situations the concern. This is for the reason that the courts or the tribunals, they cannot substitute their own decisions in the matters of the transfers for that of the competent authorities of the state, and even the matters of the transfers for the and even the allegations of the malafide and the when made must be such as they inspire the confidence in the court or based on the concrete the materials or ought to be ascertained. So on the mere making of it or on considerations the born out of the conjectures of the services and except for the strong the convincing reasons, no interference should be ordinarily be made with an order of the transfer. This is the settled position, my lord, unless such thing.
This is regarding transfer order.
My lord.
This will apply to 30 May order, not to 12 June order.
Well, 12 June order, as I have already pointed out, madam, that is the only the limited submissions, madam. So this is the settled position. It includes overall, madam. This includes, madam, the overall, is because, madam, this is the settled position, madam. This is the only, madam, the so far, madam, it has not been overruled. This is the position, madam.
Yes.
So therefore, madam, this is and madam, of course, it is not, madam, as Lordship has already pointed out, that madam, the subsequent joining and non-joinings will not make any difference in view of the the partial modification order, madam. So, madam, I'll not go into depth in that aspect, madam. But however, madam, the submaterial has been suppressed. Madam, he has not come with the clean hand before this honorable court, madam.
Which one?
Hand,
Which one?
madam, the petitioner.
Which is the subject matter of
This
Which is
also,
subject
madam,
matter
madam,
of
in our affidavit.
another writ petition?
No, madam, it has been also raised specifically in this affidavit also.
What has been suppressed?
Suppressed, my lord, the material documents has been suppressed is because he has never joined, my lord. The state respondent has also given the, my lord, this is the suppression, my lord, as I have, my lord, I'll not, my lord, on that.
Okay, he has not joined pursuant to 30 May order.
My lord.
Can the state modify that order without a sufficient reason?
My lord.
Hmm?
Yes, ma'am.
Where is that? If you can show that the decision will go in
My
your
lord,
favor.
therefore, my lord, I have, my lord, just, my lord, I have pointed out the order of, my lord, the Supreme.
This is where I am again asking. If you want to look at that aspect, court is ready to grant you time to distinguish the decision cited by him.
My lord, that aspect, my lord, even I have done my research.
Okay, if you have not found, then order
My
will
lord,
follow.
as of now, my lord, it is the settled position, my lord, admittedly, my lord. But however, my lord, the transfer and order passed, my lord, is an incidental to service. This is the settled position, my lord. Therefore, always the competent authority is having the jurisdictions to issue, my lord, the even partial modification of the, my lord. The competent authority is, my lord, the authority to, my lord, the modified, my lord, change is always with the, my lord, the competent authority.
Okay.
So this is the transfer of the, my lord. After all, nothing, my lord. It is transfer of the, my lord. Whether it is by way of partial modification, whether it is by way of, my lord, the press order. After all, it is a transfer order. The transfer order can be modified, transfer order can be altered, transfer order can be cancelled by the competent authority. That competent, the power is always vested with this is incidental to service.
Do you have this 97 1 GLT?
That I haven't right now, but I'm aware,
Okay.
that is the
But-
settled position.
But
of
your
the
submission is contrary to this paragraph 8 of the judgment.
Really, what I wanted to point it out is, this is, somewhere it is referred, the same judgment, here in the Govardhan case, So therefore, the reason order is not reflected in the order, partial modification order itself, but it is in the file noting, therefore the file noting has been enclosed by the, annexed by the state respondent, wherein it is clearly mentions that for his proposed for detention at one particular posting place, this partial modification order has been issued is the only reason by which the competent authority has issued the partial modification order in respect of the petitioner. Rest officer are okay, they are ready to follow. Other officer is not affected, and the respondent number 4, he must be a happy person. Wherever he will go, he will have the opportunity to.
We will not say anything about others.
My lord.
We will say that as insofar as modification of the petitioner's posting from Panging to sanitation
Vice me,
has not been made with sufficient reason.
Madam.
So we interfere with that. Let him remain at Panging. That's all.
Sure, issue is, admittedly, that issue is very narrow, Otherwise, so therefore, my submission is, since I've already joined, I am discharging, I am at my new place of posting, only interim order passed by this honorable court on 20th June 2023, even after my joining, I'm not able to discharge my.
All right. You want to say anything, Miss?
Sorry, I will abide by any decision which will be rendered by this honorable court.
All right. This writ petition has been filed. Challenging the order dated 12 June 2023. Signed on issued on 13th June 2023 by the Secretary, PHE and WS, Government of AP, Itanagar by Namus at page 29. Whereby the petitioner the superintendent engineer in the department of PHE and WS has been posted to sanitation state coordinator. No, has been posted as SC sanitation state coordinator, SBMG, in modification of the order dated 30 May 2023, issued by the Secretary, PHE, WS Government of AP, signed, issued on 31st May 2023 by the motions at page 26, whereby the petitioner was posted as superintendent engineer, PHE and WS Circle, Panging. Also, para. The facts leading to filing of the present writ petition briefly stated are as under. The petitioner who was working as a superintendent engineer, PHE Circle, Alo within bracket Bene, was directed to take over the charge of SEPHE Panging Circle in addition to his normal charge. In view of the retirement of one Sri Tamuli Tako, SEPHE Circle Panging, on attending superannuation on 30 April 2023 by an order issued by the Chief Engineer dated 27 April 2023 by number so and so at page 22. Page 23 is your charge taking
Yes,
of the Panging.
Pangin.
Okay.
That is correct.
1st May.
First of.
Okay. Pursuant to the aforesaid order dated 27 April 2023, directing the petitioner to take over the charge of SE Panging Circle, the petitioner took charge of the PHE Panging Circle as superintendent engineer on 1st May 2023. Full stop. While the petitioner was working as such, namely as SEPHE Circle, Alo within bracket Bana, and with an additional charge of the PHE Panging Circle, the Secretary PHE WS Government of AP had issued an order dated 30 May 2023, had by an order dated 30 May 2023, issued on 31st May 2020 by number sense at page 26, had posted the petitioner, had transferred and posted the petitioner from Alo, Bene PHS and WS Circle to PHE and WS Panging Circle Panging, and in his place, the respondent number 4, who was working as SE, PHE and WS, Teju PHE and WS Circle, was brought in also. According to the petitioner, as the petitioner had already taken over charge of the SEPHE circle, Panging circle on 1st May 2023, pursuant to the order dated 27 April 2023, issued by the chief engineer, directing him to take over the additional charge of the Panging PHE circle Panging. The petitioner continued to discharge his duty as SE, PHE and WS circle Panging. In terms of the order 27 April 2023 issued by the chief engineer, as well as in terms of the order dated 30th May 20, in terms of the transfer and posting order dated 30th May 2023, issued on 31st May 2023 by the Secretary PHE and WS Government of AP. Post. While the petitioner was working as such, as SE, PHE, WS Panging circle, the Secretary PHE and WS Government of Arunachal Pradesh issued yet another order dated 12th June 2023, issued yet another order dated 12th June 2023, issued on 13th June 2023. However, in modification of the earlier order of transfer dated 31/5/2023, the petitioner has now been posted as SE Sanitation State Coordinator SBMG by number and so on at page 29. SBMG comma, the respondent number 4 has now been posted as SE, PHE and WS circle Panging, and the respondent number 5 has been posted as SE Arlo, Bene PHE circle. The petitioner, therefore has filed the instant writ petition challenging the impugn transfer and posting order dated 12 June 2023, issued on 13 June 2023, contending that the earlier order of transfer dated 30th May 2023, issued on 31st May 2023, issued by the Secretary PHE, WS Government of AP, could not have been modified without assigning sufficient reason, and therefore the impugn transfer order dated impugn order dated 12 June 2023 issued by Secretary PH Extension on 13 June 2020 is liable to be interfered with. State respondents 1, 2, and 3. Contesting the case, contesting the writ petition, the state respondents 1, 2, and 3 have filed a counter affidavit wherein it has been contended
I'm sorry, my lord, on the last occasion, my lord, the record was also called for from the state respondents, my lord. It is also, I hope to give, my lord, available with the,
for what purpose?
my lord, just to see the, my lord, whether there is a, or, the how order was initiated, my lord.
Does anybody has disputed, they've annexed the file noting.
Admittedly, however, my lord, the original file must be, my lord, with them, my lord.
It's here, madam, but we have already annexed in our.
No, it is your document. Whereby it has been contended that the earlier order of transfer dated 30 May 2023 was modified on a proposal put forth by the Honorable Minister PHE. However, it was proposed that the writ petitioner be retained as SE Alo, Bennett PHE Circle, and respondent number 4 be posted as SE Panging, and one engineer Tony Ete. He is EE or
Yes.
executive engineer Alo be posted as in charge SE Teju PHE Circle. Which proposal was This proposal was sent to the Honorable Chief Minister. Has it been mentioned in the affidavit? That is what, where?
Just a minute.
Minister has been mentioned.
Chief Minister, they have not mentioned. They have only said the said proposal was not considered.
Just a moment. Minister PhD has been mentioned.
Yes. Chief Minister has not been mentioned.
Chief Minister has not been mentioned. Okay. Which proposal on being put up to the competent authority? Was modified. Was modified. Thereby posting the petitioner as SC sanitation, state coordination, SBMG. Post of. The state authorities in the counter affidavit contains that it was in pursuance of the approval of the competent authority as above, that the impute modification of transfer order dated 12 June 2023 was issued, posting the petitioner as SC sanitation state coordination SBM in modification of the earlier transfer order dated 30 June 2023. Full stop. You also say the same thing in your affidavit?
Yes, ma'am. And that part, madam, we have also raised that.
Has the state in the affidavit said that you did not join pursuant to
Yes.
order dated?
Yes,
So that's why they have modified it.
Just a moment.
they have said.
They've said so, no?
Yes.
Okay.
Just.
Not exactly modified was done, not for non-joining, but clearly stated that he has not joined, madam.
They have said the earlier was in terms of the internal arrangement, in terms of the 30 order. That is
Okay.
them.
In terms of 30.
They have.
Okay. The state respondents in the counter affidavit have also contended that the have also contended that though the petitioner was working as SC
Para 11, madam. Para 11, madam.
just a moment.
11, 12.
SC PHC Panging Circle in terms of the order dated 27 April 2023 issued by the chief engineer directing the petitioner to take over the additional charge of SCPHC Panging Circle. The petitioner did not join Panging PHE and WS circle pursuant to the pursuant to the order of transfer dated 30 May 2023, issued on 31st May 2023 by the Secretary, PHE and WS, Government of AP. And since and therefore the order of transfer dated 30 May 2023, posting the petitioner as SE, PHE and WS circle Panging was modified by the impugn order dated 12 June 2023 by posting the petitioner as SE Sanitation State Coordinator SBMG postal. Now you also say the same thing, or you say any additional?
Well, in addition, of course, Lordship has already pointed out and observed that subsequent to the joining and the subsequent to the handing and taking over charges, and which is completely manufactured by the petitioner, it is also not relevant. But we have taken that plea also in our affidavit.
Which one is manufactured one?
Joining report from assuming charges, the entire thing, page number, specifically
Joining report
of the petitioner.
petitioner
He has
taking
never
over
joined
the
in pursuance to the order dated
of the chief engineer's order. Taking over as an additional charge.
additional charge is as per the chief engineer, that is in
Ah.
along with his substantive.
No,
that-
petitioner himself says that he did not.
Yes, yes.
He did not join because it was not necessary for him to join. He was already working, is not it?
But our respectful submission is in pursuance to the subsequent order, it is the order of the competent authority, it has to be given effect by way of releasing, by way of proper joining, After all, it is an order of the competent authority,
Okay, then you say like this.
Yes.
That is same thing. See,
More or less, same thing.
state has said that he did not join pursuant to the earlier,
Correct.
the 30 May order.
Correct.
So that's why they have modified it.
Correct.
And petitioner is also not saying that he did join after 30 May transfer order was issued.
But that is the irony, without joining, how charges has been assumed? That is the question, That is my question put to myself, that without formally joining, without formally being released from the earlier place of posting, he straight away taken the charges, by annexing, the charge sending and taking over of the charges. Annexure 4 of my affidavit, And all the way on the same day, when the transfer order was
Yes, where is annexure 4?
page number 18. That is the contentions which we have raised in our affidavit, All the way, even that is a distance of more than 400 kilometers from Teju to Alo, Bene.
No, it's not 400.
That hardly makes any difference.
Page number 18 of my affidavit.
This history.
I'm sorry, page number 20, annexure 6.
20.
How this has been done, without formally being released, formally being joined, this handing and taking over of charges, is completely contrary.
Will that have any bearing on the merit of the case?
True,
You may raise arguments of any sort, but will they, even if I record it, will they have any bearing on the merit of the case? Page number 18.
20,
20.
annexure 6. It is on to be handed over on 12 June 2023. And Onyok Madung, who was serving at Teju, all the way he reached Alo to give handing and taking over of charges,
Respondent number 5.
Yes. Respondent number 5 is me, my lord. Regambo.
What about your contention? You also, you have also said same thing as the government, or you say something different?
No, your lordship, I have nothing to offer comment, your lordship.
And my lord, this issue letter, my lord, memo number is given in the bottom line, my lord.
What is the,
This
does the
one-
respondent number 4 say anything in the affidavit?
They only said that in terms of the earlier order, he has also complied and there's a stay in this place or in the to the lordship.
On merit, he has not
No.
said anything. Okay.
Absolutely.
Respondent number 4 has filed a counter. Respondent number 4 has filed a counter affidavit. Wherein it has been stated that in terms of the order of transfer dated 12/6/2023, the respondent number 4 has joined at
At all. In terms of the order dated 30.
30.
Yes. 30.
And in a modification where he was sent,
Pangin in my place. There is.
okay.
date.
You have said you have joined at Alo.
Yes.
That is specific point, my lord, we have disputed, my lord.
No, your lordship, there are two order dated, that's why I was confused.
And he has respondent number 4 by affidavit, my lord, he has said that he has not joined is because he was out of his station for medical treatment, my lord.
No.
Yes, sir. Respondent number 4 has filed an affidavit
Casual leave, my lord.
wherein it has been stated that in compliance of the
Sorry, college admission, of
order
Sons College admission, I'm sorry.
transfer order dated 31/5/2023. The respondent number 4 had joined at his place of posting at Alo, and thereafter the impugned order dated 12/6/2023 signed on 13/6/2020 was issued by the respondent authorities, to which the respondent number 4 contends that it does not deem it necessary to controvert controvert the submissions made by the writ petitioner and will abide by any decision which the honorable court any decision which this court would render in the case. That is his case.
My lord.
Okay.
My lord, may I kindly
Hold on,
observe,
just a moment.
no joining report has been annexed in the, my lord.
This is his contention.
Yes.
Let it be there. Respondent number 5. Has filed a counter affidavit wherein apart from the contentions, apart from adopting the contention raised by the state respondents in the counter affidavit, has also contended that
Already joined, my lord.
that there has been no proper joining,
Release order, my lord.
there has been no proper release order,
As well
Comma.
as joining order, joining report
joining report,
and assume
and
success.
okay, comma, handing over of the charges and assuming charge of the office
My lord,
by the petitioner. Is not it?
my lord.
Full stop.
Documents annexed is all manufactured document.
Full stop. The respondent number 5 also contends that the documents annex as regards the certificate of transfer of charges.
My lord.
What else?
And for single my lord posting and transparent posting on that altogether my lord 3 charges of my lord
Okay,
transparent
transfer of charges,
page number 20.
certificate of transfer of charges.
Page number 20, memo number is different. This is not correct. My lord, we have proof also. And page number 21, annexure 7
are
is also incorrect. False documents, my lord. And annexure 8, page number 22
are
is also
false,
false.
are false document.
Fabricated, false, and manufactured document.
Are all false, fabricated and manufactured document.
Right.
For sure.
Is because from the space, my lord, register maintained by the office of the my lord, the AC banner, nowhere my lord, the same has been reflected in the issue memo, my lord. Therefore, my lord, the register of the issue memo is also enclosed. At annexure, my lord, page number, type copy is page number 26, my lord. This issue registered, my lord, mention, my lord, the registered number is my lord, different, my lord. Page number 26, type copy one. Well, for a single post, how many times joining can be possible? My lord? The assumption of charges can be possible. Altogether, my lord, 3 certificates of
But that
transfer.
is all right, but you are not contending that inappropriate assuming of charge.
That we have raised, my lord. That is our pleaded case.
If the
At
Then-
least, my lord, is for
if
enabling.
the charge is not assumed, if the charge is not assumed as per the rules,
My lord.
earlier order of transfer can be modified.
And these are all transfer of charge, not assuming. I mean,
Without
this is transfer of
joining,
charge to the
without
respondent.
joining of the my lord incumbent. My lord, I'm asking myself, and it is my out of imagine how charges can be transferred, how charges can be delegated, my lord. That is the my lord question. At least one has to my lord join his new place of posting after being released from the my lord earlier transfer of posting by the competent authority by releasing of the my lord.
All right, anyway. Mr. D. Panging Learned Counsel for the petitioner. Contents. Submits. That. As the petitioner was already working as SEPHE Circle Panging.
No, wait a
No. Panging. In terms of order dated 27th
That
April.
is my lord, in addition.
Okay.
In addition to his successive post.
Submits that as the petitioner who was working as SEPHE Circle Alo within bracket Bene was had also taken over the charge of SEPHE Panging Circle in addition to his normal charges in terms of order dated 27 April 2023 issued by the Chief Engineer PHE and WS Department. And the petitioner having been transferred and posted as SE, PHE and WS Circle Pange by the order dated 30th May 2023. Issued on 31st May 2023 by the Secretary, PHE and WS, Government of AP, by number so and so. The respondent authorities could not have modified the said, did I say, posted as at Pange, etc. By order dated 30th May 2023. Was, did I say? The respondent authorities could not have modified the order of transfer and posting order dated 30th May 2023 within a span of less than 2 weeks, I think.
Yes.
Within a span of less than 2 weeks by the impugned order dated 12 June 2023, issued on 13 June 2023 by transferring the petitioner as SE, sanitation, state coordination, SBMG, without sufficient reason. According to him, there was absolutely no, according to him, the respondent authorities have not assigned any reason for modifying the earlier order of transfer dated 30th May 2023 by the impugned order dated 12 June 2023. In support of his contention that the order of transfer issued cannot be modified by the respondent authorities in such a short interval without sufficient reason assigned. He has relied on the decision rendered by this court in the case of Rokul Holi, Angami versus State of Nagaland and others, 1997, 1 GLT 140. Mr. Tapin, non-senior government advocate, on the other hand, has contended that has contended that since no malafide has been alleged against the respondent authorities in issuing the impugned modification, in issuing the impugned modification of impugned order dated 12 June 2023. Whereby the earlier order of transfer and posting dated 30 May 2023 has been modified. This court may not interfere with the impugned order dated 12 June 2023 in the absence of any allegation of malafide exercise of power by the respondent authorities in issuing the said impugn order dated 12 June 2023. Poster. By referring to the counter affidavit filed by respondents 1, 2, and 3, he has fairly submitted that from the affidavit file and the annexes appended thereto, no reason is discernible from the record for modifying the earlier order of transfer dated 30 May 2023 by the impugn order dated 12 June 2023. Full stop. Where is stopping? He also contended that you did not join, that's why there has been a modification.
Same thing, yes.
Ah.
In terms of the 30 order, I
On
think
30 order, you did not join, he contended, is not it?
orally, I
Huh? Okay. We'll continue at 2. Mr. Tapin, what was your contention regarding his joining? He did not join after this order of transfer dated 30th May. Then what?
My submission was that since the transfer order was invoked two things. One is if the transfer is made in interest of public. Secondly, it also touches the interest of the employee. Here, since he has not moved in terms of the transfer order, then it is not prejudice. That was my lawsuit.
He has moved.
He has not.
He has de facto moved
He has-
by the order of chief engineer.
But not by the, in
Ah.
terms of the impugn order. Because we are going to examine the impugn order. He has not moved in terms of the impugn order.
not impugn order, 30
No.
order. Impugn order, we have challenged.
Sorry.
Why will he move?
No, 30 order, 30 May order.
Ah, 30.
He has not moved in terms of the 30 order, 30
No.
30 May order.
Not joined in terms of 30 order.
Yes.
You know, then what happens? If he has
Therefore,
not
he
joined,
is not prejudiced.
okay, he has not proceeded.
Because basically, when in terms of transfer order, when the employee moves,
Ah.
then the modification and
Mr. Tapin Lane, senior government advocate, has also contended that since the writ petitioner has not formally joined or moved in terms of the transfer order dated 30 May 2029, sorry, 23, no prejudice is caused to the petitioner, and therefore the impugn order dated 12 June 2023 may not be interfered with by this court, is not it?
laws.
Full stop. Adopting, what is Kato? Adopting the argument, adopting the submission made by the learned senior government advocate, Mr. Tapin. Before that, let us submit the, here 4 is not it, okay. Miss Liha, M. Liha. Miss M. Liha, learned counsel, appearing for the respondent number 4, has by relying on the counter affidavit filed by the respondent number 4, has contended that in terms of the transfer order dated 30 May 2023, the respondent number 4 had joined at Alo PHE and WS Circle and thereafter the impugned order dated 12/6/2023 has been issued, modifying the earlier order of transfer order dated 30/5/2023, and the respondent number 4 would abide by any decision that may be rendered by this court in the writ petition. Full stop. Adopting the submission of learned senior government advocate Mr. S. Tapin, Mr. Kato, learned counsel representing the respondent number 5, has contended that since the proposal for modification of the transfer order dated 30 May 2023 did I say proposal for modification was initiated by the department through the Honorable Minister PHE. The competent authority who had issued the earlier transfer order dated 30 May 2023 is well within the competence to modify the earlier order of transfer dated 30 May 2023 by the impugned order dated 12 June 2023. Full stop. He further contended that in the instant case, the modification proposal as put forth by the department through the Honorable Minister PHE was for posting of the petitioner at as SE Alo Bene PHE Circle. But when the matter was put up to the competent authority did not agree with the said proposal, and thereby the writ petitioner was posted as SE Sanitation State Coordination or Coordinator SBMG. Any accordingly contents that since the authority competent to issue the transfer order is also competent to modify the order of transfer earlier issued. And that is why in the instant case, the competent authority did not accept the proposal put forth by the department or the honorable minister concerned. And the petitioner was posted as SC Sanitation State Coordination, SBMG. Also. He accordingly contends that since the impute modification order dated 12 June 2023 has been issued by the competent authority, the said impute order may not be interfered with in the absence of any other ground footfall other than the contention of the petitioner, that no reason has been assigned for modification of the earlier order of transfer. In support of his contention that the transfer of an employee normally should not be interfered with by the court, except when the transfer order is shown to be vitiated by malafide or in violation of any statutory provision, or having been passed by an authority not competent to pass such an order. He has relied on a decision of the Honorable Supreme Court in the state of UP versus others versus Govardhan Law 2004 11 SCC 402. He has also contended that the writ petitioner has not assumed the charge of SC Panging, SC PhD WS Panging Circle as per the procedure prescribed, and according to him, the documents annexed by the petitioner. What is that? Transfer of charge?
Yes, to the respondent number 4.
Okay. Namely, the certificate of transfer of charges are all, he said, false and fake.
Yes, fabricated.
False, fake, and manufactured documents, and therefore not in accordance with the procedure prescribed for transfer of charges as well as for assuming charges. In that view of the matter, he has contended that the impute modification order dated 12 June so may not be interfered with by this court. First, arrival submissions, advance with the counsel for the parties have received due consideration of this court. Upon hearing the learned counsel for the parties and on perusal of the materials on record, it is noticed that the petitioner, it is noticed while the petitioner was working as SC, PHE and WS circle, the WS Alo within bracket Bene Circle. The petitioner was directed to take charge of the SEPHE pumping circle, the additional charge circle by the chief engineer PHE WS department. Namsai, na? This Namsai. Chief engineer is Namsai, station at Namsai.
Yes, yes.
Okay, chief engineer WS department Namsai by the order dated 27 April 2023 by number so answer at page 22. Full stop. Pursuant thereto, it is also noticed that the petitioner had taken the additional charge of SEPHE circle, PHE pumping circle on 1st May 2023. Full stop. While the petitioner was working as such, the Secretary PHE and WS Government of AP had issued the order dated 30 May 2023. On 31st May 2023, by number so and so, whereby the petitioner has been transferred and posted, has been transferred from Alo, Bene PHE and WS circle to PHE and WS circle Panging. And in his place at Alo, the respondent number 4 has been respondent 4 who was working as a SE, Teju PHE and WS circle has been brought in. Postcode. After the aforesaid order dated 30 May 2023 was issued by the Secretary PHE WS, Government of AP, it appears that respondent number 4 had joined at Alo PHE and WS circle, though the exact date of joining has not been mentioned in the counter affidavit file. Also, it further appears that since the petitioner was already working as SE, PHE and WS Panging circle since 1st of May 2023, in terms of the order dated 27 April 2022 issued by the chief engineer. The petitioner, though did not formally join in terms of the order, transfer order dated, transfer posting order dated 30 May 2023, but the petitioner continued to discharge his continued to discharge the function of SE, PHE and WS circle Pangin. While the matter situated thus, within a period of less than 2 weeks, the impugn order dated 12 June 2023 has been issued on 13 June 2023 by the Secretary PHE and WS Government of AP.
Respondent number 4 as in the affidavit says, in the forenoon of 12/6, transferred charge to Tony Etta, and in the afternoon took over charge at Alo.
But in the affidavit, he does not say so.
Affidavit is say.
Affidavit?
Yes, paragraph,
Where?
paragraph five,
Paragraph 5.
yes,
Uh,
last part. Ma'am.
the answer is when handed
This is clarified there.
on phone and thereafter travel to took charge from petitioner in the afternoon. Okay. Then you join in the afternoon of 12/6/2023. You say, where we said, though no date has been indicated, na? You said 12/6/2023. Yes, Miss Lika, you have missed this, huh? Well, less than 2 weeks. Within less than 2 weeks from 30 so and so. The impugn order that 12 June 2023 was issued by the issued on 13 June 2023 by the Secretary PH and Government of AP, whereby in partial modification of the earlier order of transfer, earlier transfer order of event number dated 31/5/2023. The petitioner has been posted as SC Sanitation State Coordination SBMG, comma, the respondent number 4 has been posted as SE PH and W Circle Pangi, and one engineer Regam, and the respondent number 5 has been posted as SE Alo Bene PH Circle. Postcode. By number so and so, huh? At page 29. Postcode. The in the aforesaid in the light of the above facts, what calls for determination by this court is whether the respondent authorities, after having transferred the petitioner from Alo Bene PHE and WS Circle to PHE WS Circle Pangi by the order dated 30 May 2023, issued on 31st May 2020 by the Secretary, etc., by the number so and so. Could the respondent authorities have modified the said order within less than a period of 2 weeks? Therefore, by the impugn order dated 12 June 2023, issued on 13 June 2023 by the Secretary, etc., by the number so and so, whereby the petitioner has been now posted as SE Sanitation State Coordinator SBMG. Poster. There is no dispute with the proposition of law as contended by Mr. Tapin Lane, Senior Government Advocate, as well as Mr. M. Kato Lane, Counsel for the respondent number 4. Sorry, 5. That transfer of an employee is prerogative of the authorities concerned, and the court should not normally interfere therewith, except when one, transfer order is shown to be vitiated by malafidis, or two, in violation of any statutory provision, or number 3, or number 3, or the transfer order have been issued by an authority not competent to issue such an order, which proposition has been laid down by the Honorable Supreme Court in the case of Govardhan La Supra. Poster. But in the instant case, unlike the law laid down in the case of Govardhan La Supra, the issue that requires consideration by this court is not the order of transfer issued by the authority, by the respondent authority, but the order of transfer and posting issued in modification of the earlier order of transfer and posting issued okay, is not the transfer and posting order is what I said firstly. Is not the order of the transfer and posting issued by respondent authorities, but the transfer and posting order issued in modification of the earlier order of transfer and posting issued issued 12 days earlier. Issued just you read like this. No, but not the transfer and posting order issued by the respondent authorities, but the order of transfer and posting dated 12 June 2023 issued on 13 June 2023 by Secretary so and so in modification of the earlier order of transfer issued barely less than 2 weeks before, dated 30th May 2023, issued on 31st May 2023 by the Secretary, PhD, etc. When it is the case of modification of the earlier order of transfer issued by the respondent authorities, it is a settled position of law that cancellation or modification order just a minute. That cancellation or modification of the earlier order of transfer must be supported by a sufficient reason, because transfer of officers are always made in public interest and after elaborate exercise as to who should be transferred where in the exigency of the administration. Full stop. Therefore, once the transfer order is issued, it is normally presumed that the same is made in public interest. Also, reference in this regard may be made to the decision of this court rendered in Roku, etc., Angami, 1997, 1 140, wherein in paragraph 8 thereof, it has been held as follows. Also, keeping in view the above proposition of law that the cancellation or modification of the transfer order issued earlier should be supported by a sufficient reason. In the instant case, from the counter affidavit filed by the state respondents 1, 2, and 3, it has been noticed that the earlier order of transfer dated 30 May 2023 was issued on 31st May 2023 by the Secretary, etc. On being approved by the competent authority. Full stop. Thereafter, the file on which the transfer and posting leading to issuance of the earlier order of transfer dated 30 May 2020 on 31st May by the Secretary was recalled by the was recalled for modification and the And the same was resubmitted. Was recalled. And a proposal was resubmitted at the initiative made by the Honorable Minister PHE, PHE and WS, wherein the petitioner's posting was proposed as SE Alo Bene PHE Circle. Oh, pardon, is 4. Respondent of 4. Okay. And that's comma. Respondent. Okay. All right. Comma. Respondent number 4 was proposed to be posted as SE Panging, and another engineer, Tony Ete, he is not a party. No. Executive Engineer Alo was proposed to be posted as in charge SE Teju PHE Circle. Posto. The above proposal was submitted, forwarded to the competent authority for approval, wherein the competent authority did not accept insofar as the proposed posting of the petitioner at SE Alo Bene PHE Circle, and thereby the competent authority approved the posting of the petitioner as SE Sanitation State Coordination SBMG. It was full stop. It was pursuant to the above that the impugn order dated 12 June 2023 was issued on 13 June so and so, whereby the petitioner who had been posted as SEPHE and WS Circle Panging by the earlier order of transfer and posting dated 30 May 2023 has been modified, and the petitioner has been posted as SE Sanitation State Coordinator SBMG. Posto. Thus, from perusal of the materials placed by the state respondents in the counter affidavit file, no reason is discernible as to why the competent authority who had earlier approved the posting of the petitioner at Panging has now been sought to be modified and posted as SE Sanitation State Coordinator SBMG by the impugn order dated 12 June 2023. Full stop. In the absence of any reason much less the sufficient stock adequate reason as held by this court in the case of so and so 1997, Supra. I am of the considered view that the impugn order dated 12 June, etc. Posting the petitioner as sanitation coordinator, etc. in modification of the earlier order of transport dated 30 May 2023. Cannot be upheld, and the same requires interference by this court. Accordingly, the order dated so and so, 12 June, issued by so and so. Insofar as the petitioner is sought to be posted as sanitation coordinator, SB, etc. in modification of the earlier order of transfer dated 30 May 2023 issued on so and so, whereby the petitioner has been posted at the Panging circle, etc. Shall still interfered with. Writ petition is allowed to the extent indicated above and disposal.
And the second item, my lord, that will be fixed after a week, my lord.
Not after a week, my lord, I will have to file affidavit. Item number 12.
After
2 weeks time.
3 weeks, I'll file it.
3 weeks, okay. We'll grant them time to file affidavit. But Mr. M. Carter,
Copy is also not in further.
learned counsel for the petitioner, and Mr. D. Pangin, learned counsel for which respondent?
My lord,
Respondent number 4.
Four.
Who pressed for and is granted 2 weeks time to file counter affidavit listed up to 3 weeks.
my lord. Okay.
Deeply blessed.
Lordship, we need some time to file affidavit here. I have received the instruction.
Okay. How much time?
3 weeks, Your Lord.
3 weeks. Mr. Ivan,
Yes, Your Lordship.
learned counsel for the petitioner, and Ms. R. Russell, learned government advocate, who pressed for and is granted for the 3 weeks time to file counter affidavit listed after 3 weeks.
Obliged.
Made to the law.
Mhm.
My lord, this is a matter, my lord, wherein the petitioner suspension has been extended periodically. On the last occasion, my lord, on 27/6/2023, while issuing notice, records were called for to ascertain what are the reasons for extension.
Yet to receive records, my lord. I have not yet received.
They filed their affidavit, records were required to be called.
Oh, you have filed the affidavit?
Yes.
Okay. How much time?
2 weeks, my lord.
Okay. Mr. D. Learned counsel for the petitioner, and Ms. T. Wangmo, learned government advocate, who pressed for
2 weeks, my lord.
for the 2 weeks time to
Bring on the record.
produce the relevant record. As per listed after 2 weeks.
Okay, my lord, this matter may be listed for hearing.
Hearing, who? Who is for the other side?
Mr. Kato. Matokat.
Pro forma. And where is this? Pleadings have been exchanged. What is the matter about?
Matters basically, we've challenged call of interview at a different location. Change of place of interview.
Okay. Mr. D. Lalji, Islamic Council for the petitioner. Union of India. M. Kato is for Union of India.
Yes.
Okay. Chief Secretary is also there.
Actually, they are not required. Secretary has also, they are just,
Okay. You are for whom?
I'm for two man, the secretary has.
T. Tagum, okay, T. Tagum for Standing Council Health Department, respondent. Mr. Kato. You are representing Union of India here. He says pleadings have been exchanged and matter may be posted for hearing. What do you say? Okay. And M. Kato learned DSGY for R3 and 4. Learned counsel for the party submit that pleadings have been exchanged and the matter may be listed for hearing. First, admit listed for hearing in due course.
Interim order may continue.
Interim order passed earlier shall continue till the next date of listing. What is this contempt case?
Contempt is the violation of order passed by this.
Okay, listed along with WPC.
Most of it.
My lord. I need some time to file rejoinder.
What? Rejoinder.
Yes, ma'am.
What is the matter about?
My lord. Matter is
Keva.
regarding. Yes, ma'am.
He wants to file rejoinder. What do you say?
Yes, Your Lordship, we have already filed our counter affidavit on behalf of respondent number 4, 5, and 6. Your Lordship.
Last occasion also, they have submitted that they will find the last occasion.
Yes. Can the matter be disposed of? Not today.
Not today.
Okay. 2 weeks further time is granted as prayed for by Mr. M. Doji,
Yes, ma'am.
counsel for the petitioner to file rejoinder. Listed after 3 weeks. As per-
Obliged.
May I please, Your Lordship? Your Lordship, I pray for an adjournment of this matter for 3 weeks, Your Lordship.
Contempt case.
Yes, Your Lordship.
You are appearing for respondent.
Respondents, my lord, on behalf of Mr. U. Boring. My lord, on last occasion, that is 27/2023, petitioner was granted 4 weeks time to implement the present.
Yes, Your
incumbent.
Lordship.
Just a moment. You are representing the respondent. Order complied with.
My lord, I do not have instruction as on today.
What is the order?
Order is the page number 20, Your Lordship. Operating portion is page number 22, Your Lordship. Annexure 3, Your Lordship.
Why you are seeking adjournment?
Your Lordship, actually, my senior Rindu Sekia is not here today. Moreover, we need some more time to trace out the, address and detail of the respondents.
How many respondents are there?
3 respondents are here.
You are representing whom?
1, 2, and 3.
They represent.
No, my lord, during the pendency of this contempt proceeding, 1, 2, and 3, they have been transferred out. my lord.
Okay.
They have to implement the present income.
Yes.
On the prayer of Mr.
I am.
I will council for petition listed after 4 weeks.
Highly obliged.
Yeah. And in this case, on the last occasion, on 12th of July, notice was issued by this honorable court. However, we have missed out on taking steps to the respondent. Hence, this honorable court may.
Okay, Mr. T.Y. Butil, Lana Council for petitioner press for is granted 1 week time to take steps for service of notice upon the sole respondent as directed by the order dated 12/7/2023, listed after 4 weeks.
Value.
In item 20, may I pray for 2 weeks time to file affidavit, my lord,
File what?
counter affidavit.
2021, is not it?
Yes, yes,
You are,
IA.
you seem to be appearing for the petitioner.
yes, my lord. But I.
My lord, IA has been filed for implement, madam.
Implement.
Implement
Okay.
of respondent is the applicant herein is respondent number 7, madam.
Do you have any objection?
Yes, my lord, we want to.
You want to file objection to
Yes,
this?
ma'am. 2 weeks time.
What objection? Why you want to implement this person?
My lord, early round of writ petition, my lord, the LPC was cancelled, my lord. My lord, the specific order is, my lord, we have also annexed the
Okay,
copy.
let's give them some time.
Yes, my lord, 2 weeks.
Mr. M. Kato, run the counsel for the applicant.
Madam.
Yes. G. Run the government advocate, associate for. You will not file objection, is not? Okay. Okay, and Mr. S.K. Devi. Run the counsel for the opposite party,
7 to, my lord.
7 to 12. They are the petitioners.
Yes.
Opposite parties, 7 to 12. Stop read petitioners. Who press for and is granted 2 weeks time to file objection.
Well.
Listed after 2 weeks.
Apply.
May I, my lord? In this case, my lord, we are challenging the impugn, my lord, notice issued by Deputy Commissioner, my lord. Where,
Yes, you have filed affidavit.
My lord, we have filed affidavit, but we are not pressing, my lord. I have no objection to the prayer consider.
Okay.
The petition.
Liberty may be given. The authority. To proceed to the case.
Okay. Which is the impugn order?
impugn order, my lord,
It, Deputy
Against the
Commissioner
prisoner
Sama-
so majority, my lord.
Page number?
Page number 30, my lord.
330.
Yes, sir.
330.
Last paragraph.
Petitioner is Nawang Tinle,
Now,
Yeah.
I think that
Yes, ma'am.
GV of Mutual Government. Deputy- Mr.
T comes.
T. Kamsi Learned Counsel for the petitioner. Mr. S. Tapin, Learned Senior Government Advocate representing respondents 1 and 2. And Mr. K. Dubey, Learned Counsel for the respondent number 3. This requisition is directed against the letter dated 31st January. 31st January 2023.
Yes, madam.
Issued by the DC cum District Magistrate Tawang. By number at page 30, whereby in view of in view of the complaints dated 2/9/2022, 5/9/2023, 19/9/2023, 26/9/2023, and 25/12/2022, the petitioner has been directed to prove majority in his support to continue as GV Gambura of Muchut Gormang village or submit resignation from the post of GV within 60 days from the date of issue of this notice. Telling which post of notice. Not post of notice. Just a moment. Issue of this notice by contending that there is no such provision under the law for proving of a majority by the Gambura in order to continue or remain as Gambura of a village. First off, the learned Mr. S. Tapin, learned senior government advocate, representing the state respondent, as well as Mr. K. Dure, learned counsel representing the respondent number 3, have considered to the contention raised by the petitioner. Also, in view of the above, having heard the learned counsel appearing for the parties and on perusal of the materials available on record, since no provision of law has been referred to by the Deputy Commissioner Tawa while issuing the notice dated 31st January 2023 to the petitioner, this writ petition is hereby allowed by setting aside the impugned order, impugned notice dated 31st January 2023 issued by the DC District Magistrate Tawa by number so and so at page 30 or so. Not possible for want of any supporting provision of rules or law or rules for issuance of such notice. It is ordered accordingly. However, liberty is granted to the respondent authorities to proceed against the petitioner in accordance with law if there are any complaints against the petitioner. Just a moment, not liberty. Setting aside of the impugned notice dated 31 January 2023 issued by the Deputy Commissioner Tawa to the petitioner shall, however, not deter the respondent authorities from proceeding against the petitioner in accordance with law if there are complaints against the petitioner. The petition is disposable in terms of
Much.
Lordship. On last occasion, Lordship, we were directed to serve a dusty service upon private respondent number 3, Lordship.
Dusty service is completed, Your Lordship. We are
Have you filed affidavit?
not yet, Your Lordship.
Okay, you file affidavit?
Yeah, 2 weeks maybe.
Okay. And the prayer of Mr.
T Tarin, Tao Tarin.
Taring, learned counsel for the petitioner. Listed after 2 weeks.
2 weeks.
To enable filing of an affidavit regarding dusty service on which respondent?
Respondent number 3.
On respondent number 3. Listed after 2 weeks.
All right.
Number 24.
My lordship. Lordship, respondent number 1, 2, 5, 6, 7, and not yet filed affidavit, lordship.
Okay. Who is representing 1?
1, 2, 5, 6, 7.
1, 2, 5, 6, 7. Who is representing 1, 2, 5, 6, 7?
1, 2, and
Okay. Yes. You want to file affidavit?
Some more time.
Okay. Add Mr.
K. Lawrence, lordship.
K. Lawrence, counsel for the petitioner. D. Come to standing counsel LM for 1 and 2. G. Additional senior counsel for R 3 and 4. SK Jamo for
Respondent number 7.
respondent number 7. Who is representing? Okay. AT will also represent 6. PWD division. Assistant engineer. Proforma.
Lordship,
Whatever it is. It is your
fine for 3 and 4 we have filed already.
already filed. Okay. And who is representing 5? BKV. What dispute you have with 5? Huh? Your dispute is with BKV.
Yes.
My lord, basically the petitioner challenging the establishment of the BKV in a community land.
Okay.
And if the community land belongs to 3 villages. 2 villages have no objection, but particular 1 village, there are some minority people who are before this honorable court. But the majority wants the establishment of the BKV. So in the very first they have status quo. So I'm the one who's suffering right now because I'm the one who
Status quo granted.
Yes, sir. So it is serving no purpose to anyone at this stage. As my men and material are being wasted since this matter was filed.
See, it is like this. This land is owned by you and him, is not it? It is a community land.
I'm a private contractor.
Or you are a contractor.
Yes.
Then, all right, you are a contractor. Community land. But each member of the community will have to agree.
Yes, fine.
They have a
there are
agreement.
only petitions of only 18. There are almost 100 households.
18 is not important.
Yes.
Let us find out.
Majority, the public consensus has to be there. They cannot represent 1 village, 18 people cannot represent the whole village.
Hmm.
There are 100 households and majority wants the BKV to be established. And in a place like Lumla, there are no such schools. So after much persuasion, this school was allowed to be built in that border area at Lumla.
Object is laudable, no doubt. But they also have some rights. We have to take along everybody.
When it is a community land, 18 people cannot decide. There has to be a general consensus from the whole village.
You are donating it for free. You are donating the land for free.
Yes, my lord.
For
They have
establishment
given-
of BKV.
They have given their consensus in the NOC, willingness certificate was also there.
Okay.
They have come before this honorable court after almost a year.
when already substantial amount of work for the school has been done.
Anyway, let us find out. Have you taken steps for service notice to respondent five?
Yes, Lordship.
Where? I don't find any nothing. You have not taken steps.
Sorry, Lordship. Lordship. One more time for taking a step for respondent number.
Lordship, we have filed our affidavit already. On this stand only, Lordship, this status can be vacated. Lordship, they have,
This is what, government land or what?
Lordship,
Is this a government land?
no government land, but the Lordship, since they have given, that's why, Lordship, it has been tendered and the respondent number 5 was given.
They have given means, let us see where it has been given. Page 25, I think,
36, Lordship, kindly come to page 36.
36.
36 of my affidavit. Lordship.
But it is a private land, sorry, community land, not a government land.
Admittedly, Lordship, admittedly.
No, we'll have to hear it. What is your role? You are a government.
Lordship.
It is a, see, BKB is not here. BKB wants a land to establish. So majority of the landowners, they are willing to give. But 18 of you, is not it?
Only
You does not want to give.
Lordship, I am not challenging the,
You want compensation.
no, Lordship, I am not challenging the Lordship, BKB, construction of BKB school, Lordship. I am
Ah.
challenging the willingness and NOC certificate which was fraudulently taken by housewise camping through the administrative, Lordship.
That's what they are, Lordship, saying, but then Lordship, 60 persons, the Lordship, they have signed the NOC, Lordship. No objection certificate has been given by them.
Lordship, let the matter may be passed over for next week, Lordship.
Then those persons should also come before the court.
Yes, ma'am. And the status quo is serving no purpose. It's only delaying the whole development activity.
Okay. Learned counsel for the petitioner shall take steps for service or notice upon respondent number 5 by registered post with AD as well as by usual process within 3 days.
Obliged.
List it after 4 weeks.
Madam, 4 weeks to be.
There's no-
2 weeks, madam.
3 weeks.
Let it come up in October, first week of October. Lordship.
That is 3 weeks.
2 weeks, Lordship.
Okay, 3 weeks. We'll say 3 weeks.
Yes, Lordship.
What affidavit you will file? It is neither your land,
Yes, Lordship.
neither your land nor
That is
Miss
the
Address
biggest
land.
one. That was what I can gather from the petition, Lordship, with that, Lordship. If at all, this is not a government land. And it seems that it's a private dispute in between the 3 villages. Since they are saying that this land
Mhm.
belongs to 3 different villages.
We'll consider all
Whether
those.
it will lie or not, Lordship, that is something, Lordship.
That is also there.
Yes,
Yes, correct. We'll consider all those
yes.
after
Lordship.
3 weeks.
Lordship, status quo maybe.
Okay. Interim order passed earlier shall continue till the next date of listing.
Lordship, I kindly observe, Lordship, if
No,
since-
no
since
observation.
they have
Steps.
yes, given 3 this time to take steps to respondent on number 5,
You make that submission on the next date.
Lordship.
You have to take steps.
Obliged.
Yes.
May I please first?
Yes,
Here is the main case.
But in main case,
Where
I
the
think not full 25.
number 4 and 5 has already filed the affidavit. Counter affidavit. Then we have filed a miss case. Miss case
for vacation,
to bucket the stay order, which was passed on 7/8/2000.
government, who is for the government?
Yes, my lord.
Affidavit file.
No, my lord, they have no.
Government will have to file affidavit.
Yes,
Mr. S. Lampu, Learned Counsel for the petitioner, Ms. K. T. Wangmo, Learned Government Advocate, representing respondents 1, 2, and 3, and Mr. M. Pati, Learned Senior Counsel. Which respondent?
4 and 5.
4 and 5, I'm at the
Representing respondents. Respondents number 4 and 5. You have filed counter affidavit.
I have filed
Okay.
counter affidavit.
Who
And
signed?
apart from that, I have filed the IA work.
Who submits that the counter affidavit by the respondents 4 and 5 have been filed. You will file within how much time? Huh? 2 weeks, okay. On the other hand, Ms. T. Wangmo, Learned Government Advocate, press for, and is granted 2 weeks time to file counter affidavit by the respondents 1, 2, and 3. As prayed for district after 2 weeks.
There is for main, I think, the IA. What about the IA?
My lord,
I have filed IA.
my lord, in main case, my lord, there is interim order.
Okay,
Hello.
in the interim order, first I'll just continue till the next date of listing.
And in IA, my lord, notice has to be superseded. There is no notice.
No, no, IA.
Yes, ma'am.
Okay, IA will issue notice.
I think we have not should be noticed.
Had Mr. M. Patin, Learned Senior Counsel for the applicant, and Mr. H. Lampu, Learned Counsel for the
41. Opposite 41.
opposite party 1, writ petitioner, and Ms. T. Wangmo, Learned Government Advocate for OP number 2, 3, and 4. Issue notice returnable in 2 weeks.
2 weeks.
2 weeks. In the IA, huh?
Wait, President.
Hmm.
Well, this is a bail application, my lord, earlier this was rejected, I'm now on my lord, on health grounds only. Your lordship may consider. Earlier on merit, your lordship has rejected.
Yes.
Your lordship may kindly have page 36 for a moment, page 36.
36.
Yes, we filed an application to have the accused person examined. He had an accident earlier, my lord, before his arrest.
Yes.
There the direction was issued to have him, have the accused person examined at TRIMS. Then my lord will have page 38.
30?
38. This is by the jail authorities. Was referred to TRIMS, my lord. Your lordship may see serial number 8.
Serial number?
Serial number 8.
8.
Yes, present history.
Yes.
Backache and joint pain, difficulty in walking. Hypertension and all, my lord, I will not. Past history, it says accident surgery in 2021. Then my lord will have page 39. I have now been referred for surgery, my lord, at Negrims. Spine problem, my lord. 11.
Chief Medical Superintendent.
Yes. Spine surgery. Serial number 11.
What surgery?
Spine surgery.
Spine.
Spinal
Spine surgery.
So my lord, may kindly considered in that respect only, maybe interim. Because it's a spinal problem and my lord, even the charge has not been framed till there. 44 witnesses are there.
Yes, Mr.
Well, CBI has filed objection petitions,
Ah.
raising the objections that specific allegation is at page number 3, paragraph 3, affidavit filed by the CBI,
All this, my lord, I'm not on that, my lord.
Paragraph 3.
My lord.
I'm only
So
on
this
the-
is the seriousness of the
No.
case.
See, he says that he wants. He says that spine surgery, he has been recommended at Nigrims.
My lord.
It cannot be done here.
Maybe not, my lord, that is why the chief medical officer.
It's for the instruction, my
We
lord.
will not grant bail. Can we allow him to go to Nigrims and get this, spine surgery done and then come back to jail?
Yes, my lord.
That
Subject
is
to
his
how
prayer.
The doctor's advice.
That is his prayer. You have filed objection on merit.
Merit, my lord, as well as my lord.
Merit, undoubtedly, it is serious.
Yes. I'm not on because your lordship already rejected it. In fact, your lordship can keep this pending. In the meantime, I'm go there.
How long it will take?
That is why I don't know, my lord, because ultimately, once I go there,
You get that instruction.
but that is something only a doctor can say.
No, you see, that's why you have visited the doctor.
Yes.
Doctor will opine, say,
I think, my lord, this opinion can only be given by the spinal surgeon and Nigrims. Or, yes, Nigrims.
what do you say? What do you say?
My lord, of
My
course,
lord may direct us to report to the investigating agency as what is the doctor has said and class consequential orders.
my lord, before,
Okay, without bail, can in the police custody, can he go to Nigrims?
Then they will have to take us. That is the cost of the state. That is the problem.
Then you have to take him there.
my lord, in that case, my lord, may I pray that, my lord, I may be allowed to take instruction as because
You take instruction on this,
yes, ma'am.
is not it? Whether you will take him, or you will allow him to go. Let him take instruction. Okay.
Tomorrow, after all, this is spine surgery and there are 44 PWs. Even charge has not been framed. November last time it was.
When?
Tomorrow, my lord. See on
Tomorrow.
instruction.
Okay. And list it tomorrow. Venerable Mr. Kato, standing council,
My lord.
CBI
CBI.
to receive instruction in the matter.
Problem.
Develop.
Your Lordship, Mayor, I'm appearing on behalf of J. Gini Jungam Gini. He's out of station, Your Lordship. He was.
Okay. When do you want? You are for the petitioner.
My lord.
When do you?
He informed me to list this matter on Friday, 15th, Your Lordship.
What is the matter about?
Regarding the appointment, my lord.
Appointment.
Appointment, private respondent number 4, my lord, private respondent, no. They have not participated in the, my lord, selection process. But
You-
however, my lord, from other sources, they have been appointed, my lord.
You are challenging this appointment,
Their
5 to 9.
9, my lord. Friday, my lord, subject to.
My lord, this is exactly as per our statement. Their appointment is not against direct recruitment. They were appointed against the contingency service, my lord.
That is the illegality,
25% of the contingency
Keeping the
service there. And the petitioner, the claim is that when he's in waiting list, while the other party, but our stand is, madam, their source of appointment is different, madam.
That is the only illegality, my lord, keeping them so many windows, my lord, just to appoint. My lord, on Tuesday, my lord, and Tuesday 19, my lord.
Okay, 19.
My lord.
Huh? Not 2 weeks. Okay. On the prayer of the council for the parties listed on 19.
And your lordship, on item number 23, there was an interim. I failed to address this. Item number 23.
23.
Yes, there was an interim.
Okay. Interim order passed earlier.
Shall
Continue till the next date of listing.
oblige.
Met for your lordship.
Yes, 22 matter fixed.
Well, it's fixed and it is otherwise we have filed a writ petition manual basically saying that I am occupying a plot of land. I have got my own installations there. And the land belongs to my father from whom I have inherited. Apart from that, there is a will also executed by my father. Now, the respondent government has filed an affidavit stating that the land was acquired and compensation was given to the owner and my father was not the owner. But LPC has been issued to me. I am occupying the land on the basis of an LPC. Now, they in the affidavit about the LPC, they say that LPC was not issued correctly, it should be cancelled. Now, I cannot cancel it, they have to cancel, government has to cancel. Their stand is that the land was acquired and it was given to APEDA. Energy Development Agency, Arunachal Pradesh. Now, Lordship may straightway come to, I'm possibly there is a way to dispose of the matter with a short order, man. Page 54, Lordship may kindly see, this is the order which I have challenged.
Just a moment.
Ma'am.
Yes,
My lordship may kindly have a look at page 50 first, man.
page,
50 of my writ petition. Possibly there is a short way of disposing of the writ petition. Instead of going into the other issues.
50, yes.
My lord, this is the LPC issued to me. This LPC is still valid. This is to certify that the land area measuring 36,747 square meter only of land described below is in possession of so-and-so, common resident of village, Rono, PO, Doimuk, district, etc. This certificate is issued on the report of EAC, CO, Doimuk, as communicated by letter number so-and-so, dated 3rd of March 2008, as well as NOC from DFO, Bandedava, number so-and-so, dated 4th of April 2008. Now, based on this LPC, even otherwise prior to this, I've been occupying. Now, page 54 is the impugned letter.
Yes.
Whereas a letter received from the Deputy Commissioner UPI White number so-and-so dated 29th October 2021 in compliance of the letter from Director APEDA White number so-and-so dated so-and-so of the APEDA Itanagar effect that you are encroaching the allotted land of APEDA White number so-and-so dated so-and-so, an area measuring 5,734 square meter at Bhutto village undergoing circle, and thereby issued notice against the Department for vacation of land properties from the said land, whereas it is revealed through the record that the land has been allotted to the Rail Works Department Itanagar during 1992 after maintaining due procedure, and later the same plot of land was handed over to APEDA White number so-and-so dated 12th of September 1997, and till then the land is utilized by the APEDA. And whereas it is revealed that the land has been verified by Dr. So-and-so, EAC, Roimuk on ground on 7/6/2021 in presence of Gaungura Sri Tana Topusi so-and-so, Chairman, so-and-so, representative from Srimati Tana Aruna and official teams from APEDA, and found that the land measuring about 2,712 square meter has been encroached by Srimati Tana Aruna, wife of Sri Tana Nekal, within the allotted land of APEDA. Therefore, you are hereby directed to refrain from doing any activities within the allotted land of APEDA at Bhutto village, following which necessary action shall be initiated against as per the provisions of law. Now, this is in the form of a temporary injunction issued.
You are in, according to them, you have encroached 2,712 square meter.
My allotted land is LPC is in respect of 36,747 meter. They are saying that I have.
Have you noticed for what purpose your land is? Your land is for residential purpose.
Yes.
36,747 square meter.
In the LPC, my lord.
Yes. How many family members you have?
That I will find out.
36,000.
It's quite a huge area. No, my lord, land. My father was in possession of the land. My contention is my father was in possession of the land.
What could be the area of forget about Raj Bhavan. Raj Bhavan cannot be that big.
In fact,
Presidential palace.
Actual dispute is with regard to 5,000 square feet only. Out of that, in the
You
affidavit,
sacrifice your 2,700
no, my lord. Now what they are doing is the place where I am occupying.
square meter. Then also you will have 34,000 square meter.
My lord, that is there. Your lordship, what your lordship is all right, my lord. Voluntarily, I can do that. My lord, what I am saying is, my lord, if a person is occupying government land, we have got an act in the state, my lord. State government has legislated this 2003 Act. The Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2003.
No, have you read the order of this court?
My lord. Earlier, Lordship had
See,
taken
they
away.
had filed for the vacation of the stay order.
My lord,
All right.
my lord.
There, this court had made an observation. The root cause is the deputy commissioner.
My lord.
We don't know whether this LPC may be genuine,
My lord.
but in the ground, on the ground level, whether
What is the
it is
position?
correct or not. This is not the only instance. There are huge, lot, thousands of this. See, there are fake LPCs are also being circulated. It looks like
No, my lord, about the
genuine one.
my lord, about the
But
issue.
there is something in those LPCs that is missing. But if you look at it, everything is genuine. Signature, seals.
There
we
may
don't
be
know.
some. But so far as this
And
LPC is concerned,
after all, what is LPC? It
possession.
is a certificate of possession. You are not in possession.
No, I am in possession.
APEDA is in possession.
No, my lord. That is why my lord, the problem. I am in possession. They are saying that you have encroached. It is an admitted fact, my lord, in the affidavit also.
So we
Lordship may direct.
we dispose of this writ petition, leaving the parties to approach the civil court.
Yes. Or
Whether you approach, whether they approach, we don't know.
Lordship, that is there, but then Lordship, if we come to the Lordship merit of the case also, Lordship, this petitioner is not the owner of the land, Lordship. The petitioner's father was just a signatory in the, Lordship may kindly come to this one. Who is the owner? We have paid the compensation already, Lordship.
My lord, your lordship will not decide the ownership of the land. What I am saying is, my lord, admittedly, I am owning the land, I am possessing the land. And you have passed an order in the form of a temporary injunction.
How do we?
Authority is not a civil court. my lord.
Lordship, Lordship may kindly come to.
Let me complete. Just 5 minutes. I'll just complete within 5 minutes, my lord. Yes. Well, my submissions are twofold. One, if you say that I am encroaching a government land, then we have got a procedure, and the procedure prescribed is action has to be initiated under this Arunachal Pradesh Public Nuisance Eviction of Unauthorized Occupants Act 2003. A whole procedure is provided therein. Secondly, my lord, LPC, rightly or wrongly, an LPC is existing. The LPC also says that ESC.
See, just a moment.
My lord.
Ms. Ete,
Lordship.
impugned order is at page 54, is not it?
My lord.
Lordship,
Whereby you have given him notice,
2000.
given a notice
Yes, Lordship.
to refrain from doing any activities.
My lord.
Yes,
Saying that he is in encroachment of 2,700 square meters
Yes,
of
Lordship.
the land of the APEDA, right? Not it.
land of the
Allotted.
Apeta, Lordship.
Allotted.
Allotted land of the.
No, this letter has been stayed by this court.
My lord, possible.
Is it?
Status quo, Lordship. Yes,
Oh, okay, status quo.
was granted on this.
Why don't you resort to eviction of a public premises, etc.,
yes.
whatever is there?
Lordship,
We will keep this writ petition pending.
Lordship, that we have tried, but then the authorities, what they are saying is because the matter is before the honorable court.
No,
Lordship,
we'll observe that. We'll observe that.
we have already given advice that Lordship, the authority can move for the cancellation of the LPC also, but then they say their Lordship kind of scared because this is in the higher forum, Lordship. Anything if they do anything, it will be
Well,
contempt of the court,
I have
Lordship.
understood. My submission before Lordship will be, and my suggestion rather, that Lordship may dispose it up with a observation that if the allegation is that I am occupying a government land, for eviction of a person who is unauthorizedly occupying a government land, there is a procedure prescribed, they can take recourse to
For the
this.
LPC, Lordship, that kind of eviction cannot be given. At the most, it can be, Lordship, okay, LPC can be cancelled.
Then
And
LPC,
then Lordship,
there must be
we have
some
shown
court
clear-
challenging the LPC.
Have you
Let me. complete, sir.
approached the authorities for cancellation of this LPC?
Yes, Lordship, we have.
Okay,
We
then what happened?
Lordship, they have said so, Lordship, since even the petitioner have approached that you cannot do anything because the matter is before the High Court already, and anything you do would be the contempt of the court, Lordship. And then they are under the impression that they can't do anything. Lordship.
Well, Where is that record of
Lordship,
approaching
that
the
record, Lordship,
appropriate
if the,
authority? The
Lordship, if
cancellation?
the IA is with the Lordship is, we have annexed that in the IA.
No, you see, case is like this. They say they have been allotted
In 1992.
1992. It can't be, see, that is why there is an observation in the order passed by this court in their IA that the root cause is
Deputy
that,
Commissioner.
see, they also have allotment order. You also have LPC,
Yes.
which overlaps with the allotment order.
Part of the land.
So you can't
Part.
simply say that
Their LP is
if you are in occupation of a government land, you can be evicted.
Yes.
They have, if LPC is a title, allotment is equally a title. I think allotment is better title than LPC. So they have a better title.
No, my lord, LPC will be higher.
No.
I'm giving the reason. My
See.
lord. Land belongs to government. In LPC also land belongs to government. I am only.
See,
posing.
just a moment. This is within the jurisdiction of Papumpara DC.
Should be. Papumpari, yes, ma'am.
Yes, Lordship.
Papumpari.
Papumpari.
It is mentioned in.
Lordship, may kindly come to
Sell,
my
sell, sell,
46 also. This already compensated to
Just-
one person, Lordship. It's not.
sell, can we direct the deputy commissioner to verify, to make a physical verification
Yes, Lordship.
in the light of overlapping allotment and the LPC?
If your Lordship comes, that
In the-
verification
in the-
has already been done.
Huh?
That physical verification has already been done after
Where?
the complaint of the Lordship, the
Where?
director of the APEDA.
Where it is?
Lordship may kindly come to. Just a second.
I think best way will be physical verification.
Lordship, that has already been done. I am sorry, Lordship. Kindly bear with me, Lordship. Lordship may kindly come to page 65.
60,
65.
65. Just a
Lordship,
moment.
yeah,
No,
type copy is at 67.
just a moment. Type copy is just 67.
Yes, Lordship, page 67.
This verification was done on your complaint.
Yes, Lordship. Proper verification. This one was there for. Lordship, may I?
Yes.
It directed by SDO Doimuk on 7 June 2021 with respect to complaint letter forwarded by the LRSO UPIA with above mentioned details. A ground verification of the matter was conducted by ESC, Dr. Nikita Pangam, HGB, Siri Tana Topu, and LM staff Siri Take Nyokir. Both the parties were also pre-informed regarding the verification schedule.
Both the parties were present.
Yeah,
when-
Lordship, may I
when-
say?
Just a moment.
The petitioner, Lordship, sent a representative. Lordship, yeah. However, Srimati Tana Aruna, wife of Sri Tana Nikam, the alleged encroacher was absent. On one of her relatives, Sri Tana Deep, came as her representative, Lordship. The project officer here so-and-so showed us some documents related to the issue. A notification dated 13 March 1992 by Secretary Land Records directing the ADC Naharlagur to acquire a land measuring 5,734 square meters for RWD department with details at them was shown. Another document was as ordered by Secretary RWD dated 12/09/1997 directing instructing the RW department to transfer some assets to APEDA. Here in Annexure A, serial number 16, a demonstration plot measuring 0.57 hectares has been listed under Doimu block. Copies of both documents have been enclosed for authorities perusal. He told us that initially APEDA was under RWD department. Later RWD department got bifurcated and APEDA is a separate department today. The existing APEDA building is bounded with walls on all sides. Lordship, existing on all sides. However, the area demarcated by the boundary wall doesn't cover the area of 5,734 square meters. The project officer informed that the present wall had been constructed in 2007-8. At that time, the river Dikrong flowed very close to the wall at the southern portion of the department land. However, in recent years, the Dikrong River has again changed its course, exposing a considerable portion of land by the river. The surveyor was directed to mark out the department land overlapping with the alleged encroacher's plot. After subtracting the area demarcated by the boundary walls, a remaining area of 2,000 meters, 2,712 meters was calculated.
Just a moment.
Lordship,
Where is your allotment order?
Lordship may kindly. Lordship, we have, in this case, we have followed all the, after notification in Annexure 1, Lordship. Lordship, Annexure 2 is the, Lordship. Lordship, see here.
No, your allotment order. You have been allotted, is not it?
Yes, Lordship.
There is an allotment order, is not it?
Allotment, Lordship, is self, this Lordship, in Annexure 2, Lordship will see.
She is appealing for the government. I think.
APEDA.
No, APEDA is different, it's an agency.
Lordship, here, Director APEDA is there, though agency, but
I don't
we have a
because
department.
Department says. that
You are, just a moment, you
Lordship.
are representing whom?
Lordship, here in this APEDA.
APEDA, is not it?
Yes, Lordship.
Yes, respondent of 5.
Yes, Lordship may kindly come to,
Affidavit is by APEDA.
yes, Lordship may
Okay.
kindly come to Annexure 2, Lordship.
Yes, affidavit is by APEDA.
Lordship.
No, do you have an allotment order?
This itself is Lordship.
Page.
Schedule, Lordship may kindly see 36 also,
Page number 36.
36. Lordship, the ADC Naharlagan Lower Subansiri District is hereby directed to take order for acquisition of the said land as per provision of so and so.
No.
A plan of the land may be inspected in the office of the ADC Naharlagan Lower Subansiri, so and so. Lordship see here, Lordship may see in the Kaliumpur 5,734 square meter, and the here Lordship, North Fairweather Road, South Dikrong River and Sri Yoa Agap, East Yoa Agap, West Yoa Agap, and he is the Lordship, owner of the land, Lordship. And we have paid to the,
No, I'm just,
allowed to complete,
I'm
Lordship.
sorry, I'm not interrupting. This is not allotment. This is a declaration under
No,
6 of the Land Acquisition
Sorry,
Act.
from here, I'm so
No,
starting
land
from here,
acquisition is
Lordship.
mentioned here, section 6 of the Land Acquisition Act. Because my lord, procedure is, there has to be a preliminary notification under section 4, then declaration under section 6, then award under section 11. This is
No,
second stage
If
declaration
that
under
is so,
section
Lordship,
6.
the petitioner doesn't have any reason, Lordship, to say this, complain about this. He is not the donor of this land also, Lordship. He doesn't have any right, Lordship. Lordship may Annexure, Lordship, page 42, Lordship may kindly come to page 42, Lordship. This may be perused, Lordship. This was even published in the Lordship, paper, in 2 papers. And finally, Lordship, this page 44, Lordship. Page 44, Lordship. 13 March 1992, Lordship.
Just a moment.
Page 44, Lordship. Number and date of preliminary notification, Lordship, this has been given here on the next column, page. Date, Lordship, March 1992. Situation and extent of the land, Lordship, is given here. And Lordship, description of the land, WRC land, Lordship. On 6, Lordship, name of the person with interest in the land
You,
and the.
just a moment. You come to page 64
64, Lordship.
of your affidavit, yes. Second paragraph.
Yes, Lordship.
Whereas it is revealed through the record that the land has been allotted to the Rural Work Department, Itanagar, during 1992.
Yes,
After maintaining due procedure, and later, the same plot of land was handed over to APEDA
yes, Lordship.
by number so and so dated 12/9/1997. Where is
Yes.
this? Where is this document?
Yes, Lordship, we have annexed, Lordship.
Let us see.
Lordship, let me take to the main Lordships.
Page 56.
Lordship, all this we have stated also, Lordship, in the paragraphs. In our paragraphs, Lordship, statement.
Where is annexer A of this? Annexer A of this document?
Lordship, is the Lordship, may
Page,
time
page 56,
56.
where
Lordship,
you refer to as per list at annexer A.
Lordship is this one, Lordship, page 58. There has been some.
Page 56.
Yes, page 58, Lordship.
Page 58
Yes,
is the annexer.
yes, Lordship, of this A.
But this does not contain the area of the land.
No, Lordship, it all the
What
Lordship,
see, what the court is trying to find out is the area of land.
Lordship, here, though area is not mentioned, the governor of AP is pleased to, Lordship, order the transfer of SS building when it was, Lordship, bifurcated, Lordship. NRG wing was bifurcated from the RWD, Lordship. This whole portion was given to handed over to the Lordship. This office, Lordship, may kindly transfer of SS buildings, vehicles, land, etc. Lordship, may kindly see this, Lordship. From rural works to Arunachal Pradesh NRG Development Agency, as per list and XRL, Lordship. These are the Lordship equipments. Basically, they have written it down, but then Lordship.
See, if you are
Well,
asked,
it was-
if you are asked to show how much area the APEDA has, from where you will show from the documents.
Lordship, may kindly come to.
Difficulty is
Lordship.
coming because the river is changing course from time to time. I am occupying a plot of land which has come up after the river changes course. Now they are saying there is some overlapping. If the overlapping is only 2007, or let it be found out. Where is the, and they on the one hand they say it is already demarcated by a boundary wall.
Well, Lordship, petitioner father is not the owner at all here in the first case, Lordship. All through fraudulently, she have a Lordship obtained the LPC without taking NOC from APEDA, Lordship. Lordship, may kindly. Lordship, may kindly come to deed of agreement, Lordship. Lordship, may kindly come to page 52. 50. Deed of agreement, Lordship.
Your affidavit.
Yes, 50. Deed of agreement between the Lordship. Petitioner, Lordship, the landowner and the Lordship. RWD Lordship.
See, sometimes you say donor, sometimes you say it is acquired. When you,
Lordship, we have given compensation already.
acquired,
Land was acquired properly, Lordship, acquired properly.
when you have acquired, where is the question of donation?
Yes, Lordship, sorry.
In one
See,
page there.
you, see, Miss,
Lordship,
you
this
think
is after the Lordship acquisition, this Lordship, page 50.
you think about this aspect, we'll take it up some other day.
Lordship, may kindly,
Which one?
can it be taken up tomorrow, Lordship?
Tomorrow?
Yes, Lordship.
Tomorrow what?
Lordship, because as I have already told Lordship, because of this status quo order, Lordship, the building, construction of building has stopped already, Lordship. Because in the 3,000, that one bounded portion only we are constructing, but then they have, Lordship, stop that also, Lordship.
But you saw one document
Yes, Lordship.
that you have been allotted or you were in possession of 5,734 square meters. You have to show this.
Lordship, 53, page 53, Lordship.
Page 53.
This was given to Director Land Records, Lordship, acquisition of land for IREP cell RWT Toimuk settlement of objections thereof, Lordship.
And where is the land acquired?
Land acquired is, Lordship, this is settlement, Lordship, may kindly see.
Where?
Settlement in the next copy, Lordship, page 54. After this, Lordship.
This is to declare that there was no complaint objection to the land acquisition of
Page 44 is the award map.
Page
Lordship.
44 is the award.
Yes.
Lordship, land boundaries
So
also.
they have mentioned about proceeding because possibly the officers are not aware. After section 6 declaration, they have to pass an award under section 11. This is the award,
Page 44.
page 44. Type copy is also there, I think.
Land acquisition proceeding under section 11.
Yes, page 46 is the type copy. Lordship may read from there.
Acquisition of land for establishment of
This
IR?
Zone, Lordship.
IR
IREP, Lordship.
EP.
Project under RWT at Toimuk, Lordship.
Okay,
Name of project,
just
Lordship.
a moment.
Lordship,
All
for item 4, Lordship.
Allotment order
right,
is not
okay.
there.
This is according to is the award.
This is the award because my Lordship can see left hand side column.
Yes.
First, they have given as required under the Act, preliminary notification in section 4. Then next serial number 3 is the declaration in section 6, which he has
Yeah.
shown as allotment order. There is nothing to do, that has got nothing to do with the APEDA. This is a part of the land acquisition proceeding, section 6 award. Then therefrom under the Act,
Lordship, land
under
was
section
acquired
11.
for this department only, for this
Yes.
department only.
Yeah.
That's why, Lordship.
Just
Under section 11, it has to be.
So
My lord.
by this
Lordship,
document,
My lord.
Amount was also paid by the department only, Lordship. RW department.
this was for the RWD department.
Yes, Lordship.
When was this handed over to
Lordship.
APEDA?
Handed over, Lordship may kindly come to my. Nineteen 96, Lordship.
Where is the document?
Document,
There
Lordship.
there is no such document.
Lordship, that order of the governor, that one self is. That
Lordship.
Where is that page number? 56. Assets and building.
Yes, Lordship. That is that. It's 1997, 12/9/1997, and Excel 10, Lordship.
Okay.
Lordship, this land was acquired for the RWD department only, and then Lordship, compensation has been paid by this department only, Lordship.
All right, all right.
Lordship.
Then you tell one thing. Come back to page 44.
44, Lordship.
This is the land acquired for RWD, is not it?
Yes, Lordship.
Here the area is 5734 square meter,
Yes,
which was handed over to the APEDA.
yes.
Now, if today, if you are to identify this land, how will you identify?
Lordship,
this is
in
the-
the 3,000 is
Lordship
already bounded now,
Lordship is
Lordship.
absolutely correct. If
Lordship.
the award, they have to give the area which they have taken.
Lordship, the area is already, boundary is here, Lordship.
See, Miss Ate,
Lordship.
this question is coming from the court
Hmm.
with a purpose. This query is made so that if we are to direct some authority to verify,
Lordship.
see, he has an LPC measuring 36 or 1,000 or something square meter. There, the boundary description is there.
Very vague, in fact, Lordship, that the boundary description is, Lordship.
See, whatever is there, it is by the deputy commissioner, issued by the deputy commissioner.
Lordship.
It is by you,
Yes, Lordship.
by
I
your
understand.
authority.
Understand. Lordship.
You are saying that the client which you are representing has issued a vague LPC.
It's
See,
vague.
why, see, to resolve this issue,
Lordship.
he has whatever the LPC is, he has one LPC issued by the deputy commission with a boundary description. An area, you have this document, you have the area, but you don't have boundary description. So the purpose for asking is this:
Yes, Lordship.
if this court is to direct any authority to verify
PDC.
and ascertain the land of the petitioner as well as of the APEDA, will that authority be able to do it? That is for that purpose I am asking, the court is asking, where is your land? Right or wrong? Issued by some authority. Like the petitioner has one LPC, may be correct, may not be correct.
Lordship, in the
We are
acquisition-
not saying that the LPC is correct, yes.
Deed of agreement also in the acquisition also, Lordship, the boundaries are there, Lordship. The
Deed of,
agreement, Lordship, between the Lordship,
where it
from
is?
where we have, Lordship, both the land and the
Where?
deed of agreement, Lordship, is
At page 48?
page 48, Lordship, and the Lordship,
Okay.
a type copy is
Here
at
where the road,
50, Lordship,
Dikrum
type copy
River,
at 50, Lordship,
page 50.
yes. And whereas the right, title and interest of the landowners and the interested parties in the following land herein after called the said land is as specified,
Okay.
Lordship.
In the note, according to you, Fairweather Road, South Dikrum River, is not it?
He is the real owner of the Lordship, this South Dikrong River, land of Sri Yoa Aga,
Ah,
West Sri Yoa Aga. His land only, Lordship.
no,
And
his
from
land-
him,
no,
from him only we have bought the land, Lordship. May kindly come to the settlement copy also, Lordship.
Okay,
Here-
shall we then direct the deputy commissioner to make a spot verification?
Yes,
to,
Lordship.
huh?
Yes, Lordship.
To ascertain the land,
Yes, Lordship.
okay?
With the director Lordship may dispose of, because in the order they say there is an overlapping of.
With that direction, shall we dispose of the writ petition or we'll keep
Yes,
it pending?
Lordship,
Because they.
that can be left to the, after
I'll fairly
verification,
submit.
if Lordship, 5,000 Lordship, that may not be Lordship. Direction may be given to the deputy commissioner, since they cannot do anything now because the matter is pending here, Lordship.
My lord, may I suggest one thing, as your lordship is indicating that ultimately what they are saying is there is some overlapping. And this 2712 square
No, no,
meter is
just
the.
no, just a moment. Miss Ate is, see,
Lordship.
see, if this court is going to pass us an order, huh?
Yeah, Lordship,
It will be with the consent of the parties.
Lordship.
You may reflect once again. We may consult your client also.
No, Lordship.
Because once we pass an order, it will have repercussions. Because you will be bound by it. It may go against you also in the field verification.
Lordship, Lordship, I have no objection, Lordship. We agree to the verification of that physical verification
Okay.
may be directed to the deputy commissioner, Lordship, but then fine may be given, Lordship. Limited time.
Because their
period may be-
allegation is
Then-
enforced.
Then it can be like this only, with the consent of the council of parties. This writ petition is disposed of by directing the deputy commissioner
My lord.
to ascertain the
2
land of the petitioner as per LPC, your LPC,
Yes.
and the land of the APEDA in terms of page 44 and page 50.
Yes,
Okay.
Lord. Yes, Lordship.
Okay.
My lord,
Well,
here,
And demarcate the respective land
my lord,
as would be found on physical verification.
spot. But there may be one small difficulty, my lord. That's why I'm saying in the affidavit, they have made it very clear that the river changed course from time to
That we
time.
don't know.
No, that's what I'm saying. They will do it. This one, I'm not asking this one court to do it. What I'm saying is, my lord,
And this order will also be on the consent given by the parties. Otherwise, no?
my instruction is that consent we can give only in respect of this 2712 square meter regarding which they are saying that I am encroached. This letter which I have challenged says that I have
It's already bounded, Lordship. His office is there, Lordship.
2712 square meter, they say I have encroached.
Yes.
Let them find out, let the deputy commissioner find out where is this 2712 square meter land. Where, according to them, I have encroached. Because this has to be an allotted land, number one, and number two, beyond my LPC land.
Miss Ete, your anxiety, your means the department's anxiety, APEDA's anxiety is the status quo order, is not it?
Yes, Lordship.
Then we will say this writ petition raises a disputed questions of fact regarding the land.
Lordship.
Writ petition is disposed of leaving the parties to approach the civil court.
Lordship.
Then status quo order will go
Yes, of
and,
course.
and everything goes, okay?
Yes.
Lordship. Can I just show a Lordship? Can I just show a paper to Lordship, page 54 in the page 54?
Page
Lordship.
50, yes, page 54.
On the
No, we are not going into the merits
deed of,
now.
on the deed of will only, she is saying I have taken the LPC, Lordship, the petitioner.
Lordship is not entering.
And then Lordship, if the Lordship, he is Lordship in the item one, is GB Rono, his Tessie, the father of the petitioner is. And
No,
two
see-
is your land owner, Lordship.
His LPC is not under challenge.
Where will they go?
His
Yes.
LPC is not under challenge.
No.
He has
Yes.
come to this court, you are responding. If you have any doubt on the genuineness of the LPC, you challenge it.
Yes, Lordship, we will do that, and Lordship, it can be disposed of saying that the
It raises a
commissioner may, Lordship,
It raises a
verify
dispute.
and Lordship,
Hmm?
the deputy commissioner may verify and Lordship,
No. We are disposing of this writ petition by saying that writ petition raises a civil dispute
Lordship.
regarding the ownership of a land, which is couched with the disputed questions of fact,
Yes, Lordship.
which
That's true.
which cannot be gone into in the writ petition.
Yes,
So writ petition is disposed of, leaving the parties at liberty to approach the appropriate forum for resolution of the dispute.
yes, Lordship.
Isn't it?
And
That way, the department
status
and
quo also.
status
Lordship,
quo will
let
go
the
ahead.
Status quo also, Lordship.
Yes.
stand vacated Lordship, with that.
Just before your lordship start, only one submission I will make, my lord. Regarding this 2712 square meter, my submission may be recorded that my instruction is there is a land bounded.
We are
and-
not, we will not comment anything.
No, my submission only, lordship, no finding.
Hmm.
That this part of the land which they are saying that I should not create any disturbance, I am not occupying that land, and it is an enclosed area bounded by boundary wall, my lord. This is my submission, Dr. Lordship may see this. With that observation, lordship may dispose of. Yeah.
You have challenged this section 11A notification also.
Lordship, when he is not the owner, he doesn't have any, he can't challenge this, Lordship.
We'll say that you know, you don't press this prayer.
That lordship may say.
Hmm.
Land division, I.
Mr. D. Mazumdar, running senior counsel for the petitioner. And Mr. G. Ete. You are appearing for only 5. Respondent of 5 only.
Here for 5 only, Lordship, for all but here, I'm for the 5 only here.
And what about other respondents? Did
Other
that?
respondents, the deputy commissioner, he is, did not wanted to file because
Okay.
he doesn't have.
And this
anything to
land
say.
department also has not filed an affidavit.
Lordship,
Except respondent of Apeda, nobody has filed affidavit.
yes, Lordship,
Okay.
Lordship, our, Lordship, in page 4, our, this one can be seen, Lordship, land acquisition, all process, and
Just a moment.
page 4 and 5.
And
Fine.
Ms. G. Ete, Lanet, you are what, Apeda, you are appearing as a government advocate?
Yes, Lordship,
Okay.
yes, very much.
It's an agency.
No, Lordship.
Anyway.
If you say government advocate, you may have to represent deputy commissioner also.
Lordship, I am representing all,
All.
yes.
Who is this respondent number 8? Engineer Hina
Lordship,
Azam.
he is the project officer who is in that office, Lordship.
Okay.
They have, just because he have complained their enforcement, they have made him.
By name.
Okay, then we'll say you represent all the respondents. No.
No,
Eight
Lordship,
cannot.
Huh?
no.
Eight is
eight
by
I will
name.
not, but Lordship,
HC cannot present.
Notice has been served.
now Lordship here, but we have said that he was doing on Lordship.
He
For the
has,
department
he has
only,
got no
Lordship.
personal interest, official interest, so notice, even if not, court can dispose.
Lordship.
Okay. And Ms. G. Ete, Learned counsel for Apeda will say. Respondent number 5. Is not it?
That may not be lordship, but after the Kahlana Latin.
Okay, Lana.
Normally, I'm just indicating, normally in such cases, when she is appearing specifically for APEDA, one government council could have been present just to say that he is representing. But her argument would have been sufficient.
Yes,
Normally, when
No.
procedurally.
but. And land department, you can't represent.
No, lordship, I'm not representing them.
And this respondent of 8 also you can't represent.
Yes, lordship.
Okay, we'll say then you are representing RWD. No, the RWD also not.
No,
Then Director of Land Management.
no, lordship.
Then comes APEDA, then comes Deputy Commissioner.
Deputy Commissioner, I'm representing lordship. I have taken steps also to him, but he said,
If you represent Deputy Commissioner, court has a question to ask you.
Why don't you?
lordship,
Why the petitioner shall not be entitled to the land for which you have issued LPC? You too, think over it.
lordship, that was wrongly issued by the lordship. There are so many such
No,
cases, but then
You
here
think-
is a case where, and lordship, if we
Please,
go by
please,
the
please, Miss Ate, don't fight the case with any
lordship, this may be
emotions.
kindly disposed of, lordship, because lordship, the deputy commissioner have said he that have nothing to file here, lordship.
When the senior counsel is making some vital points as far as the appearance is concerned. You say that you are representing Deputy Commissioner also. We may like to ask the Deputy Commissioner.
And
Lordship,
madam, this
in
case is
Why-
not
other
pending.
regions
why-
also, lordship had put the same question, but then there is nothing to say, lordship, by the deputy commissioner, lordship.
Lordship put
Because
this
of this-
question earlier also.
Pendency, they can't do anything also, lordship. That's why, lordship, this may
What
be
to do?
disposed of.
In fact, in the affidavit, there is one indication somewhere
Ah.
that only because some mistakes we have made, he is taking advantage. So they are admitting they in the procedure, they have made mistakes here and there.
Lordship, this may be, since this has been had so for length, lordship, this may be disposed of, lordship.
Okay. Ate for respondent number 5, 6, and 7.
Yes, lordship.
Okay, 5, 6, and 7. What to do?
So,
5, 6, 7. None appears for the remaining respondents.
Sir.
This writ petition has been filed with the following prayer. Which is reproduced here in below. 1, 2, 3, 4, and 5 at page 26. Though this writ petition has been filed with as many as 5 prayers as reproduced here in above, Mr. Mazumdar, learned senior counsel, appearing for the petition at the outset, has made it clear that the petitioner does not press the prayer number 2, 4, and 5. Full stop. In view of the above, what calls for determination by this court is the legality of.
And just one, sorry to interrupt, Lordship. I'm abandoning these prayers without prejudice to my right over the land. Definitely.
Okay, just though, then you rewrite, though this writ petition has been filed with as many as 5 prayers as indicated here in above, Mr. Mazumdar, learned senior counsel for the petitioner, has submitted that the petitioner will not press for the prayer number 2, 4, and 5 without, however, any prejudice to the right of the petitioner over the land in question. Okay, full stop. In that view of the matter, what calls for determination by this court is the legality of letter dated 24 November 2021 issued to the petitioner by the this is respondent number 7, I think. 7.
Yes, 7.
The
Yes, DO.
sub-divisional officer,
Yes.
Papumpare district, Doimuk, by number, so and so at page 54. Full stop. Not full stop, which is reproduced here in below for a ready reference. Full stop. From perusal of the impugn letter dated 24 November 2021, as quoted herein above, it is noticed that by the aforesaid impugn letter dated 24 November 2021, issued to the petitioner by the respondent number 7, it has been stated that it has been stated in the said letter that area measuring 2,712 square meters of land has been square meters of land of Apeda, the respondent number 5, has been encroached by the petitioner. Just a moment. It has been stated in the letter, I said so, that a land measuring 2,712 square meters has been encroached by the petitioner within the allotted land of Apeda, the respondent number 5. Full stop.
And Lordship, may I kindly add, which is unbounded, Lordship? Which is unbounded, Lordship?
No,
Because
well,
here also it is, Lordship, it has
I
been.
am reading from page 54, impugn letter,
Yes, Lordship.
where it is there, unbounded.
Lordship, this 2,712 is unbounded portion, Lordship.
No, no,
Then-
in the impugn letter, there is no mention of unbounded, bounded. Second last paragraph.
No, it is not there.
Therefore, the petitioner has been directed to refrain from doing any activities within the allotted land of Apeda at Huto village. Failing which necessary action shall be initiated. No, not failing which, at Huto village, stop. Full stop. Case set up by the petitioner as well as the respondent number 5 in their respective pleading, comma, in short, is that the petitioner has been issued with a land possession certificate, LPC, by the Deputy Commissioner, Papumpare District, Papumpare District, UP, by the order dated 2/2014, by number 177 DC/LM/LPC-19 at page 50, certifying that the petitioner is in possession of 36,747 square meters at Huto village for residential purpose, which land is bounded by in the north railway line, in the south Dikrong River stroke Y Tazum, in the east road stroke Tana Nyori stroke Techiami or something like that, at page 15, and in the west Dikrong River. Full stop. Whereas the respondent number 5 stroke Apeda is in possession Apeda has been allotted or is in possession of land measuring 5,734 square meters at Doimuk. Your location is Doimuk, is not it?
Yes, Huto village, Huto village.
Huto village, where it is? There is no Huto village here in the acquisition order.
Okay, Lordship, yes, Doimuk.
At Doimuk, in terms of
46
just a moment, in terms of land acquisition order or award, we'll say land acquisition award dated 25th April 1992, issued by the Circle Officer Doimuk by memo number DK/L-31/82, issued under section 11 Act 1 of 1894
Yes, Lordship.
at page 46. Just a moment. Acquired by no also active sensor for Rural Works Department, is not it? For
Yes,
Rural
sir.
Works Department,
Yes,
which was subsequently handed over to the respondent number 5, so Apeda. Full stop.
after his bifurcation from the RWD, department.
After its bifurcation from the RWD,
RW department.
APEDA was part of RWD.
RWD, it was NRG wing of
Okay,
the
okay.
RWD. Lordship.
So APEDA, after the APEDA was bifurcated from the
RWD.
RWD. Full stop.
Lordship, our document, one of the document, deed of agreement, Lordship, is in next page, Lordship.
48.
48, Lordship.
Okay.
This is signed by Lordship.
All right, the according to the respondent number 5, so APEDA, the boundary description of the 5,734 square meters of land now owned by the APEDA as per the agreement dated 19th March 1990.
Next page is the signature of first, second, and
Signed between Sri Yowa Agap,
yes, Lordship, landowner,
son of Sri Yowa Ekha,
Ekha, Lordship.
Ekha, EKHA,
Yes, GB,
GB,
village Doimo, Lordship.
Village Doimo,
Yes.
PO Doimo, and the government of Arunachal Pradesh, represented by the project officer IREP cell, comma, RWD, comma, Doimo. Is in the north, Fair Weather Road and land of Sri Yowa Agap. In the south, Dikrong River. In the east, land of Sri Yowa Agap, and in the west, land of Sri Yowa Agap.
Yes.
Page 48. Full stop. The thrust of the dispute, as can be gathered from the pleadings of the parties, is that the land possession certificate dated 14/2/2014 issued to the petitioner by the Deputy Commissioner, Papumbal District UP, as described herein above. Overlaps with the no, instead of as described herein above, you write like issued by the Deputy Commissioner, Papumbal District, certifying that the petitioner is in possession of 36,747 square meters of land at Bhutto village, overlaps with the land of the respondent of 5 of APEDA,
Yes, Lordship.
measuring
2000
no just
and cross portion is
just overlaps with the land of the respondent of 5 APEDA
To the extent of 271 and
to the extent of
27
2,700
12
12 square
meter.
meter,
Square meter, Lordship. Lordship, the
square meter.
bounded which I have said, Lordship, is in page 67 type copy, Lordship. In the Lordship verification report itself, Lordship.
No, have we not correctly described the land?
Lordship. Only bounded was not Lordship, which I wanted your Lordship to record it, Lordship, only.
In the impugn order, it is not here.
No, in the impugn order, it's not there, no?
Lordship.
We are referring to an impugn. Okay, to the extent of land measuring 2712 square meters. Full stop. Paragraph. On consideration of the rival pleadings of the parties, it is evident that the dispute raised in the instant writ petition for resolution by this court is a civil dispute between the petitioner and the respondent number 5 of APEDA, couched with a disputed questions of facts, which cannot be gone into and determined by this court in a writ petition filed under Article 226 of the Constitution of India. In that view of the matter, this writ petition shall stand disposed of, leaving the parties to approach the appropriate forum for resolution of the dispute between the petitioner and the respondent number 5 of APEDA. Also, accordingly, the status quo order passed earlier
Yes, Lordship.
stands also vacated.
So after vacating, they are entitled to do whatever they officially do, but as far as position, that status quo is to be maintained.
No,
My
beyond,
position.
beyond that, we will not say anything.
Otherwise,
We cannot go into anything, is not it? So it is for you to resolve the disputes before the appropriate forum, if there exists any dispute.
Lordship, from the beginning, the bone of this contention is that 2,712 square meter only. But then they are, Lordship, disturbing the whole 5,000. They are not allowing us to touch anything, Lordship.
Now the
That
status
cannot
quo order is gone,
Yes, Lordship.
okay? And writ petition is also disposed of.
Yes, Lordship.
So there will be no impediment for the parties to settle the disputes,
Proper forum, Lordship.
proper forum.
either amicably or before the appropriate forum.
Appropriate forum.
It is better to do it amicably.
Yes, Lordship.
All right.
We'll approach. Lordship.
Next item, contempt may be disposed of in terms of the order passed.
Okay, contempt case, okay. Add Mr. D. Mazumdar, Senior Counsel for the petitioner. You are representing the
Yes.
respondent.
Yes,
Mr. and Ms. G. Atil, Counsel for the respondent. In view of the order passed today in WPCSO and so this contempt case, there also is sent close and disposal.
Much obliged.
Okay. What is this matter? 31?
My lord, the Department of Hydropower, Government of Arunachal Pradesh has constructed a micro hydro within the sea rivers.
Matter has become infructuous.
No.
Okay, what is your prayer?
My prayer is that they have to compensate us.
Compensate you.
Yes.
affidavit filed.
Yes.
Then it will have to be heard. If there is no time, up to 2 weeks.
Yes.
Okay. Heard Mr. T. Gadi, Land Council petitioner, and Mr. S. Fabrin, Land Senior Government Advocate for the state. And the prayer Land Council for the parties listed after 2 weeks.